Santi said, Jamanatwar Aditya Astabodha. No, Aditya, no, Aditya. What I was then fighting for. What you said, they meant Jamanatwar and Aditya. Yeah. So he said he meant Jamanatwar and Aditya. और आपको कर देंगे अपन आपको हाँ वेडनेसडे राइट है आज मंडे ट्यूसडे वेडनेसडे ठीक है वो हाँ वही जाना है
Yes. It's a fresh matter or on orders, Your Honor.
My lord. Because it's a 23 matter.
Your Honor. IA came to be fined on I.
What is the urgency?
Your Honor, IA filed, Your Honor, for recalling. It was dismissed for default.
It in September only. See our convenience.
And one more matter, Your Honor. The notice has been issued in this case. Thereafter, matter has not been listed. His age of retirement is very near. Your Honor.
Take that also.
My lord, this is for vacating interim order, my lord. So,
What is the appeal? Is it appeal or?
yes,
petition?
my lord, appeal, it is appeal. So we have challenged the writ appeal of a single bench in this call.
Which
And on
year?
12
Which year?
23, my lord. So on the Honorable Court has given a status quo of interim order on 12/2/24. So kindly request for this memo to
Take that.
and list it for a short day near that
We'll give you a convenient day.
date may be given.
Have you filed an IA? Have you filed IA?
No, in order to file the IA for
You will file an application for vacation, no?
yes, my lord. And
Without an IA, how is it being listed?
I'll file today, my lord.
Just give it to her and just take that memo.
Has he filed model on vacating state?
Has he filed an IA? Just show us. There's no date. Is there any date here?
No,
Is the date there in this matter?
no, my lord, not at,
No.
no that.
Give the date. No? Yes.
Adjournments. Page number 8, 20 to 22. Page number 9, 23 to 30. Page 10, 31 to 34.
Lord, serial number 33 appear for the respondents, my lord.
For the appellant.
There are certain documents which were part of the writ petition which ought to be made part of the writ appeal.
Is the other side?
I appeal for the appellant.
The appellant is on the other side. We have to also
The
file,
respondents?
yes, ma'am. We have to also file our written submissions and list of authorities. The needful will be done.
At the request of counsel for the respondents, re-notify all.
A date.
13/9, sir.
Obliged.
13/9. Serial number 1 for non-complaints. Swami.
For a week's time to comply office objection, my lords.
You show the file.
There are 7 objections, my lords. I will comply within 2 days, my lords.
So what is wrong? What is wrong with the judgment?
But I'm a proxy counsel. Counsel on record requested me to appear, my lords, now.
The case of compassionate appointment, my lords, in the year 2011, it has been rejected. He has approached the tribunal after nearly a decade. my lords.
Argue the matter, we'll hear you.
My lords, counsel on record is next in the next court.
I will pass over,
Yes,
pass over.
Serial number 2. Raya.
Hearing for petitioner, my lord, I may be permitted to withdraw this petition, my lord. The prayer of the petitioner does not serve for consideration.
Then a counsel for the, you have filed a memo?
Yes, my lord.
Then a counsel for the petitioner has filed a memo for withdrawal of the petition. The same reads as under. The counsel reiterates the prayer for withdrawal. The petition is dismissed as withdrawn.
Serial number 3, Shri Nagarajappa. Serial number 3.
As a last opportunity, 3 weeks are granted to remove the objections. This time the objections are not removed. The petition will still stand dismissed without reference to the court. None for the, just say none for the appellant in both the matters. None for the appellants. None.
Serial number 4.
Okay, only 10 days time to complete the office submission. I already given the,
We will
Sir.
give you time.
please, man, last time.
You will remove
Last-
the objections and do the e-filing.
Right.
You will do the e-filing. Go to the e-Seva Kendra, give the physical copy, they will upload it. Will you do that?
Please, man, I already,
Huh? You will
Please.
do that.
please.
You'll record it. How much time you want?
10 days time may be granted.
2
my lord.
weeks time. 2 weeks are granted to the appellant to remove the objections. Huh?
Please,
And you will do the e-filing.
please,
Do that.
please.
Shall we record your statement?
1 second, man, I will clarify.
You have to only go there, e-Seva Kendra, and just give them, they will
I
upload
will,
it.
please, I verify and submit before this court, my lord, but
No, e-filing, e-file.
e-filing is file or not, just FR number or mention, my lord. But I will clarify that. After complaint.
After compliance,
Please, I will.
we record it. The learner counsel for the appellant states that after removing the objections, he shall file the petition through e-filing.
Please, my lord,
Okay?
please.
E-filing with the assistance of e-Seva Kendra.
Please.
Okay? Re-notify.
Sir, 17-9. Serial number 5, Shri Murugesh Charity. Serial number 5.
I'm appealing for the appellant, my lord. My lord, translate copies are ready, my lord.
How many times
Read.
in the past, man?
Sorry,
10th time.
we are very sorry, my lord.
Huh?
It's great difficult to,
He'll give you preemptorily time. Otherwise, if you don't go it, dismiss.
please, my lord. 3 days time.
How much time?
3 days time may be granted, my
We'll
lord.
give you 1 week. How much? 3 weeks or 3
3 days.
A week's time is granted to the appellants to remove the office objections. Stop. You will file e-filing, do the e-filing.
No. No, my lord, we
After
are,
removing the objections, complying the objections,
Please.
go to e-Seva Kendra, give it to them, they'll upload it.
please.
Then the counsel for the appellant submits that after removing the objection, she shall file the petition through e-filing. That's right?
Please.
Serial number 6.
I'm for the appellant in this case, my lord.
Hmm.
My lord, 2 weeks
She-
time may,
She shall also do the e-filing through e-filing also.
my lord, 2 weeks time may be granted, my lord. 2 weeks time may be granted to,
6 also,
please. my
2
lord,
weeks.
6, please.
7. Serial number 7.
That's last occasion we had taken time, my lords. Request for 2 days accommodation, my lords, will take in.
See, what is the position in that writ petition 193? Just show us this file. See,
Please, my lords. My lords are referring to the judgment of case was pending before the Supreme Court, my lords. Jagdish Sharma was,
What happened to
Please,
that?
lords, I
They
will.
say, na, there is something which is pending. In fact, that's your case also.
Please, my lord, that's one of the contentions.
Decided because the matter is pending there.
Please, my lords.
What is your now instructions on this?
Lords, I'll ascertain and submit day after tomorrow. Wednesday it may be taken, my lords.
Just 1 minute. If you go on Google search and you see Supreme Court, petition number 193 of 2015, just check up, has it been accepted? Supreme Court. Just wait, we'll let you know. Pass over.
Please.
Serial number 8, Jacob.
Okay, you have to get the correct address, my lord, I will, weeks time, maybe,
How much time you want?
weeks time.
A week's time is sought to, no, the respondent is still unserved
Unserved, correct address I will have to furnish me.
on the council.
First time I have taken it.
On the council for the petitioner furnishing the fresh address of the respondent, notice shall be issued to the respondent returnable on.
2 weeks in the meanwhile, because correct address,
Do it,
please.
18-9. Serial number 9. 9.
Something has expired. No such person now. This petitioner. The, as noted in the order dated 24/5/2022, that Sri Shashi Kanta, the counsel, and the counsel for the petitioner has expired. Shashi Kanta, no, the counsel for the petitioner has expired. On the same day, court notice was issued to the petitioner. The service report states that no person is available on the given address, on the address. Full stop. In view of the aforesaid position, we dismiss this petition for non-prosecution, granting liberty to the petitioner if any cause arrives to revive the petition by filing an application.
Serial number 10, Karnataka. Serial number 10.
Appearing for petition, my lord, not place for a week's time.
How much time?
Week's time, my lord.
Weeks time. Weeks time is, 2 weeks are granted to remove the office objections. To re-notify on.
3-9. Serial number 11, MJ Alva.
The respondent statement. Please, my lord. The case of kidnap of a minor child, my lord. A child was kidnapped. In this connection, my lord, kindly turn to the orders passed by this honorable court on 5/1/2021, my lord. Despite this order, my lord, the police have filed a C report, my lord. They have not complied with this order. Instead of complying with the directions of this honorable court, they have issued C report saying that they have closed the file. Now the state has submitted on the last date, my lord. It is
under investigation, my lord, and we were required to file reports before the District Legal Services Authority once in 3 months. So we've been doing that. In the process, my lord, there was a C report filed, which doesn't mean that we have closed the matter. Now we continue to do with the directions issued.
But what do you do within those 3 months? Do you actually
Yes,
seriously
the
carry
progress,
out?
yes, ma'am. Yes, ma'am. We, my lord, now we have taken publications in print and digital media, my lord, and all efforts have been done. We're tracking all the bodies that are recovered, unnatural death
But
reports.
Can that be so that just vanishes?
No, it's a mystery, still a mystery, my lord. We're finding it very difficult. It was transferred to the police. It was earlier with the anti-trafficking, human anti-trafficking unit.
But what does your investigation reveal? Anything?
Lord, we inquired with their parents, with their relatives. Lord, we are not getting any clue.
You will file a status report,
Yes, we are ready with the status report, my lord, which is filed before the,
at least up to date,
yes, up to date is there.
not a reiteration of the earlier one.
Yes,
Just up to date.
Yes.
What happened between this day and the next day or the previous day and this day? What have you done?
yes. What is being filed before the Legal Services Authority, my lord, would be filed here also, my lord.
That's right.
Yes.
So that we should also know. No?
Yes.
The petition is here.
Yes.
What has happened is, my lord, they had registered the moment the child is found missing, they had registered the case of kidnapping. Thereafter, they have slept over the matter. They didn't do anything. It is only after we had filed this writ petition, my lord, some action was taken.
Right, but they have filed their stand. There was an earlier round of litigation also.
There was no
So
litigation.
this 5th of January order.
My lord, then this honorable court had, after looking at the records, my lord, this honorable court had passed this order. Even thereafter, my lord, they have slept over the matter again. And this C report is filed.
No, after that, what transpired on the last occasion was that I should not file a report.
File
Yes.
your status report.
Yes.
Is it ready?
Yes, my lord. As on today also, we will serve a copy.
Copy also.
Yes,
so that
please. Yes.
The learned SPP
Yes.
states that
Yes.
the
In our copy.
status report is ready, which he shall file in the registry.
Yes.
In the course of the day, a copy of the same has been given to the counsel appearing for the petitioner, who may also respond to the same
Please.
within 2 weeks. The learned SPP states that the respondents, the respondent shall continue to carry out the investigation and shall file a fresh report.
Yes.
Before the 2 days before the next date of hearing.
Yes.
Okay, they copy to the learned counsel for the petitioner.
Grateful.
4-9, sir. Serial number 12, Rudrappa.
There is a long list of office objections. Can I stand to an exception to say some of the objections which are very trivial in matter could be rather kept it for consideration a little later and take up the IA, which is for condonation of delay of the writ appeal, where involving 222 days. It is the order against a dead person. The death of Srimati Vannamma was originally the respondent number 6. Hanumaka died in the year 1971 itself, 17 itself. The order is came to be passed in 2022 without bringing to the notice of the court at all. That resulted in delay of 222 days after we come to know about its disposal and gone against us. Immediately, the steps were taken to file the writ appeal. My lord, my reasons are very bona fide. My lord, though that delay of 222 days may be condoned, my lord. Because on the date of passing of the order, she was no more. She died much earlier to that. Unfortunately, the counsel who was representing that person in the, before the learned single judge could not able to rather brief the court about the date of death.
Where is your application 1 of 24?
At page 154.
Who had died?
The respondent sits before the learned single judge, the mother of the present appellant herein. My lord, the relevant paragraph for my lords to consider is
You were the
paragraph 6 and
contesting
7.
party.
Please, my lord,
Who is respondent number 5? Your sibling.
please,
And you were the contesting party. The challenge
very
was
much,
against-
very much, very much.
You appear for whom, ma'am?
Respondent number 1, my lord.
Respondent number 1, who appears for,
A contest, he is the lone contesting party here. And was the petitioner before the learned single
for the
judge.
contesting party. He died before the,
2017 itself,
even before the learner single judge.
very much, very much.
Now you appear for respondent number 1,
Yes, my lord.
the petitioner before the tribal, before the learner single judge.
Yes, yes.
What do you say on this application?
The notes are the copy, my lord, still not at IA 1, 2, 3 of 20.
It is gone through the process of the court.
Remaining IAs, sir.
Anyway, if my lord feels that at 222 days delay is not a small measure of delay, it is little bit higher. Lord, by imposition of caste, it could be.
You may copy to her.
I will.
Let her have a look on that.
No, in fact,
Now-
copies
now
of the
when
appeal memo and other annexes were processed through the court and service has taken place upon him.
Where is this one? IA 1 of 24.
Lastly, they're not really.
You were not knowing about the litigation.
My lord,
The litigation was not known to you.
very much. My lord, one thing, let me be very candid in my submission. That the counsel who represented me, my mother counsel who represented me before the learned single judge, did not inform me about the death of my mother, though it was taken up in the year 2022 for final disposal. And he stayed away from the proceedings and resulting in a kind of an ex parte decision is given by the learned single judge.
No, but what we find is, even the appeal is filed by, in the name of Narayanappa.
No, that is the
And
son of the respondent number
So
5.
what is serious is the affidavit. Who has filed the affidavit in support of the appeal?
My lord, in support S. Narayanappa, son of late Siddhaya. That is 156. May I invite my lord's attention to 155 and 156? Those are the IAs concerning the.
So we want to know who has filed this affidavit?
The affidavit is filed by the deponent is S. Narayanappa.
How is Narayanappa? You say Narayanappa is the same respondent number 6 before the learner single judge.
In fact, no, he is the present appellant before here and they are siblings of respondent number 6. Ponnamma.
No,
No, Hanumaka, I'm sorry. I stand corrected. Mother of the appellant.
See, simple. Narayanappa, son of Siddhaya. According to you, Narayanappa had expired before the learner single.
No, Vannamma, Hanumaka, R6,
R6 where?
before the learned single judge, as a
R6 is not
respondent number
equal.
5.
No. You
But
see the
number
memo
five.
parties, please.
Please, my lord, I have the,
Yes, see page 18.
please, my lord. In page 5, 18, Srimati Hanumaka is respondent number 5 has been arrayed,
So not 6.
not 6, I'm sorry.
So appeal is filed by respondent number 6, Narayanappa.
Very well,
Who has
and
expired?
very well,
Who has expired?
the Hanumaka, respondent number 5 before the learned single judge.
Okay.
My lord, I'm
The impression we got was 6.
Yes,
Just 1 minute.
the appeal is by the respondent number 6
Sir,
before the
application.
learned single judge.
Then let's see your application.
Limitation.
Yes, ma'am. What do you say?
Lord, we assisted her, she has the copy of the IA.
You have the copy of the IA?
We have,
What do you say then? But tell us what are the reasons you have given? But was it filed along with the writ appeal or separately?
No, it was filed along with the writ appeal.
Pardon?
It was filed along with the writ appeal. IA did accompany the writ appeal.
No, how can that be? The writ appeal is 6/3/23. The writ appeal is in March 23 and the application is July 24.
No, my lord, the application is on 21/4/2023.
See, we have
Page
IA 1 of 24.
IA 1 of 23. IA 1 of 23 may be looked into, my lords. This is filing delay. IA number 1/23, the delay occurred for the filing of the writ appeal.
There are two different things. One is the delay in filing the appeal.
Another IA is to bring the LRs of the disease on record.
No,
But
we
what
want-
I am requesting, my lord, is IA 1/23 may be considered.
We will look into that.
So that it will be rather helpful for me to rather press the entry model later.
What is the application for delay for appeal in filing the appeal? 1 of 23.
So yes, 1 of 23, 222 days.
What is the reason given in 1 of 23?
Lord, the reason is paragraph 6 and 7 would be relevant. It is on page 180, 160.
Yes.
If this paragraph 6 and 7 read with vis-a-vis with paragraph 5, rather it brings out more clarity for my lord to consider that there is a bona fide reason for me to rather seek for condonation of delay. Vis a vis, it is to be read along with paragraph 5 on the.
Yes, ma'am, what do you say?
We'll go through it, my lord. We received the file on Friday only.
Pardon?
We received the copy on Friday. So we'll go through it and we'll come.
But you have seen the reasons given in para 6.
Hmm. We'll take instruction with my senior.
No, you are the counsel for the respondent.
Yes, my lord.
One, you are the counsel.
No, my lord, my senior.
Who is the counsel? Who is the senior?
B.V. Vidyalata.
We'll just pass over, call him,
Yes.
pass.
May it be called at 2:30, my lord?
You just pass over, let's see. What are the objections made? Just 1 minute, just 1 minute. See, there are certain objections on your applications.
Lord, they are very small in nature.
No.
Nothing to it, but very prompt.
Is there any objection?
No, sir, not at all.
Okay.
There is a.
Pass.
2, 3. Bringing the legal. 13. Serial number 13. Government advocate.
For appellant, week's time may be granted to serve the notices.
You appear for whom? See, you have to serve, you appear for whom?
But I appear for the complaint in the connected matter, my lord. But,
Oh,
R1.
3.1.
Yes, but, one short question is, my lord, the institute which is admitted to grant in aid is bound to follow the roster in respect of a period prior to grant in aid. Is the short question, my lord.
Why a contempt?
But they did not comply with the order. But I preferred.
You are the complainant means, were you part of respondent 1, 2, 3 before?
Yes, ma'am.
No.
I was the petitioner before the Honorable Learned Single Judge.
Okay, now who are respondents 1, 2, 3?
1, 2, 3, my lord, but I don't have they have not served the writ appeal papers.
What is your name?
My name is, my lord, Ravi U.
Ravi, you are the petitioner.
I was the, my lord, working as peon in, my lord.
You appear for whom?
State, petitioner, state petition only,
State has
This state
preferred
petition.
appeal.
State has prepared an appeal.
Ma'am, where is that appeal? Where is that appeal?
In 307, more connected matter. Contempt.
So, but tell us one thing, was Ravi was part of the writ petition,
Yes, ma'am. I am the writ petitioner.
but now
Yes.
no, it said Nagaraj.
Nagaraj is one of the writ petitioner in 370.
Not that order.
But 307,
the
Nagaraj has
writ-
filed.
Writ petition was preferred by Ravi U, not writ petition number 13340 of 2018.
That is writ appeal number 825 of 2023, 13.2, Connected matters only.
Now tell us one thing, you have to serve respondents 1, 2, 3.
Yes, my lord.
You have to serve them,
Yes, my lord, I have to serve.
okay? Now, this contempt is against them, the state.
Yes, my lord, I'll take notice.
Now, the state of, you have to file the, you have to serve the respondent number 2 also in 13.2.
Yes, my lord.
Just say this. The
Only-
notice be issued to respondents 1 to 3. In writ petition, in writ appeal number 307 of 2023. Notice shall also be issued to respondent number 2 in writ appeal number 825 of 2023. Okay, returnable on
26/9.
now in contempt.
Yes,
Have you filed your compliance report?
not,
Take notice.
as an officer of the
Take
court, not,
instructions and that's
not,
okay.
I cannot, they need not file a compliance report, not since there is an interim order of stay of the Honorable Leonard Single Judge's order. But I cannot press for,
Then then don't press the contempt also.
but if let contempt be, but I am a retired Group D employee, not
We can't proceed with the contempt now when there is a stay.
there is an interim order of stay, my lord.
Yeah, then do one thing, you withdraw it, if you revive it, if the cause survives in future, let the appeals be decided. Okay, we are not foreclosing your right. And it cannot be.
Cannot be, not, what I would say, not, there is some urgency, not your lordship may.
We'll hear the appeal.
Yes.
Let the service be complete. See, in in view of the pendency of the appeals being, in which matter there is a stay 307
825.
in,
But this honorable court has granted interim order on 4/10/2023.
in writ appeal number writ appeal 825 of 2023. Even in 307, in these writ appeals, 8307 of 2023 and 825 of 2023. Comma, the CCC 898 of 2022 is adjourned sine die, granting liberty to the counsel for the petitioner to revive the contempt petition. If any cause survives after the decision of writ appeal 307/23 and 825 of 23. Okay?
One date,
6/9.
Hmm?
6/9.
please.
Serial number 14, Ajay Kumar.
Steps were taken.
Will this notice to respondent number 5 is still incomplete? Let fresh notice be issued to service on respondent number 5. Returnable on
24/9. 15. If I have served.
Here for appellant in this case, Lord. Lord, in this case, the office objection is with regard to the furnishing of the statement of objection, Lord, that have produced along with this IA, which has been filed under IA number 1 of 24, Lord. That is annexure A4, page 13, Lord. This is the statement of objection which has been filed before the Learned Single Judge in the writ petition 17/7/33 of 21, Lord. IA number 1 of 24. Annexure A4, page 13, Lord. The typed copy is page 38, Lord. That is only the objection.
but have you filed it on record?
Yes, Lord.
You have filed it?
Yes, Lord, I filed it, this, and also seeking permission of this court to produce certain more documents which are relevant to for adjudication of this case. In that I have produced that annexure A4 page 38.
But were they, those documents were there before the learner single judge?
Yes, my lord. These documents are not there, except A4, my lord. Other documents were not there. So for that, I filed an application seeking permission of this court to produce those documents, and the copy is also served to that my learned friend, my lord.
Appears for the respondents?
My lord, I am appearing for the contesting respondent number 6, who is the.
Five and six.
Five and six.
Yes,
My lords, please. The documents which are pertains to, yeah, I mean, under this application, my lords, please, which are not pertains to the property in question, they wanted to introduce before this honorable court by making certain allegations which are not yet proved or so things. So far as this property concerned, my lords, please, whatever the documents they wanted to now introduce before this honorable court, after the honorable single judge of this honorable court called for the original register of grant extracts and all, my lords, please, order came to be passed. Now, my lord, they wanted to see that as if no such records are there, they wanted to introduce first time before this honorable court with such things where
Have you filed your objections?
I'll file my objections to this.
One submission. The survey number 26 of that Rajaswanenalli village, that is the land is the Gomal government land block. The claim of the respondent number 5 and 6 is that this land has been granted on 29/10/1947. But my lord, this because for this respondent, my lord, in respect of another property, that is survey number 100 of same village, my lord.
We will consider additional documents at the time of.
Please,
main appeal.
that may be, my lords, please. If my lords pleases, the same are required for display.
A3, my lord.
Not even other documents of other, there are registered sale deeds of at an undisputed point of time. Any of those aspects, the matter is pending before the honorable court. The court will take into note of all those aspects also.
Which court is considering it?
My lord, land grabbing court, they have approached alleging that the property belong to the respond number 5 and 6, which is survey number 100, is a government land, and that they have made a false claim over the property. Absolutely, my lords, please, all those aspects of regarding 100, there are registered sale deeds at undisputed point of time, not recently came out. All those aspects court will be looking at. So far as this land also, my lord, we have produced the original grant certificate and grant register extract, which are called upon by the honorable single judge. After verification, there is a reference in the judgment passed by the honorable single judge regarding verification of the records from the office of the Tahsildar, my lord.
One submission with regard to that, my lord. The survey number 26 is a government Gomal land, my lord. The claim of this respondent before this court is that has been granted to them on 29/10/1947. But till date, the revenue records pertaining to the survey number stands as a government Gomal land, my lord. Thereafter, the second respondent, the Deputy Commissioner, by exercising the power conferred under Section 71 of the Karnataka Land Revenue Act, is granted this property for establishment of the solid waste management plot. And already the management, this unit has been already operating, started operation plot. In regard to that I have produced the documents. So far as that Rennet Fund is containing that.
Is that plant working there?
Yes, my lord. That annexure, my lord, I have produced the documents along with that, my lord. Annexure A2, page 19, my lord, kindly see, along with the additional documents, my lord, place it before this honorable court.
But was it not mentioned to the learner single judge?
No.
Lord, what happened, Lord? That in fact, they taken this contention, Lord, because for now the respondent number 5 and 6 are claiming that this property is granted. In another case, Lord, this same respondent with regard to that government land, which is situated in Rajaswanenalli, though it is a government land, Lord, they are entered the agreement to sell this property to some other person for a valuable sale consideration of 6 crores and received a sum of rupees 50 lakhs. So in respect of that, since after that noticing that these respondents have been committed to grab this land, the government land, they have entered that. Thereafter, the concerned authority has registered the criminal case also. Thereafter, we suspecting about this document because for the, according to them, this document, this land was granted in the 1947. But till that, the revenue records pertaining to the property stands as a government Gomal land. Suspecting about that, again we applied for the relevant document under RTI. The concerned authority has issued this endorsement stating that no such grant is available. That document is also placed before this honorable court along with the supporting documents seeking for permission to produce those documents. Already this solid waste management unit has been already started, that is operating, Lord. Besides that, Lord, in identical case, Lord, the coordinate division bench of this honorable court, Lord, in writ appeal number 16/7/13 of 2011, it is observed that a Gomar land cannot be granted to any person. That can be used only for the public purpose. That can be utilized only for the public purpose, not for the private parties. That is also the observation made by this coordinate bench, the division bench of this court, in writ appeal number 16/713 of 2011 law. Rule 1081I of that Karnataka land revenue rules is very clear that if the property is a government land, a Guntop or any other properties, that cannot be granted to any private persons, other than it can be utilized only for the public purpose. In this case, this already land has been, the Deputy Commissioner wide order dated 5/5/2020, this land has been granted reserved for the establishment of the solid waste unit management unit, and this has been already operating, Lord.
But tell us, how could how could the grant certificate of 48, it was all throughout a government land?
No, even prior to that, even till that, the revenue record reveals that is a government land. Lord.
What about in 48?
48, not that thereafter, after suspecting about the act, not I applied for that document. The concerned authority, Department of Revenue, has issued the endorsement under RTA stating that no such grant is granted in favor of this note. That is the endorsement. I placed it before this honorable court along with this document. Lord.
Who is
the respondent number 5 and 6.
No.
Their grantee, that is Iramma.
Iramma.
Yes, Lord.
It was not granted to her.
Not granted. That is also placed before this honorable court along with the documents, Lord. That is annexure A2, Lord. That annexure A3, Lord. Sorry, page 22.
You file your reply to additional documents. I think.
My
they
lords,
require-
please, I'll file my objections. They have obtained these documents after production of the original grant register extract by the same authority, wherein which this honorable court was, the honorable single judge was pleased to go through the original. The government advocate was present.
You
Please,
file-
my lord, I'll file my objections, my lord. I'll file that.
Let-
And even revenue records concerned also, my lords, please, as submitted by my learned friend, it is not the government land. The name of Iramma was continued. Her family member's name was continued. My lord, abruptly they entered as government later.
Let objections to the.
I'll file, my lords.
To the IA 1 of 24. We filed by the learned counsel for the respondent number 5 and 6. Within 4 weeks, rejoinder within 2 weeks thereafter.
Much.
6/9. 16, Kalyan Basuraj.
Paying for the respondent, my lord. They seek for a week's time to file objection to the interlocutory application what has been filed. They are seeking permission to prosecute the appeal. They were not party to the writ petition, my lord. A week's time may be granted, my lord.
Some of the officers. You appear for whom, Mr. Deshpande?
I appear for respondent number 3, my lord, the original petitioner, my lord.
In which matter? In both the matters?
My lord, in the other matter, my lord, in 16.1 also I will file wakalat for respondent number 4, 5 and 6 also, my lord.
What about 16.2?
I am not aware of the cost title, my lord. I will check the cost title with my learned friend and then I will take wakalat.
My lords, in 16, my lords, I appearing for respondent number 2, my lords. There is a office objection regarding my wakalat, my lords.
The counsel for the party, the concerned counsel for the party shall remove the office objections as notified by the registry in WA 1005 of 2023. Mr. Deshpande, who appears for some of the respondents in writ appeal number 1005 of 2023 and 52 of 2023. Seeks an adjournment. Why do you want?
Lord, he is seeking for a permission to prosecute this appeal.
not
He
a
was
party.
not a party to the original petition.
Yes.
And he's a rank stranger for this particular proceedings. For that reason, my lord, I want to
You
file
want to file
objection.
an objection?
Yes, my lord.
Wants to, seeks and is allowed to say that 3 weeks to file objections to the application filed by the appellant seeking permission to file the appeal. Full stop. The report of the registry suggests that the notice to R7 in writ appeal number 52 of 2023 is unclaimed. If that be so, comma, the notice on R7, that's right, ma'am? Notice to R7 is deemed to have been effected. Full stop. The fresh notice shall be issued in writ appeal number 1003 of 2023 to respondent number 5, 7 to 9 and 12 returnable on.
I'll play the process.
2210, sir. Seventeen, Sangamesh. Bill number 17.
Beg to appear for the appellant in this.
What's the objections is regarding non-filing of documents attached to the objections filed by the respondent number 4 before the learned single judge. Lords, the appellants herein are not parties before the learned single judge. I'm only seeking for reconsideration or remand of the matter. For this reason, Lords, the appellants were not made as parties whose name were existing in the RTC at the time of passing the order. And
No, the
Lords,
objection is, they have filed a reply, the objections by respondent number 4.
Respondent number 4 objections have been filed before the learned single judge.
That's
But the documents attached with the objections filed by R4 are not produced by me. Notes, my problem is, notes, I cannot apply the certified copies of those documents because respondent number 4 notes has produced Xerox copies. So I have only applied the objection, statement of objections, notes.
Who appears for respondent number 4?
Notes, before the
Why
learned
don't you ask the counsel who appeared in respondent number 4?
I can ask the counsel minutes, but may I request for this minutes, the respondent number 4, Mr. P. Babu is the party.
Counsel,
Yes, minutes. Mr. T. Sheshgiri Rao has appeared minutes. May I request this minutes? I have also filed a memo to that effect.
it is not. P. Babu.
P. Babu, minutes, page 21, your lordships will find Mr. T. Sheshgiri Rao is counsel for respondent number 4 before the learned single judge. And
Yes.
may I request this, my lords? Lords, keeping these objections open, if your lordships can permit me to serve on the counsels who appeared before the learned single judge for all these respondents. Lords, if they can produce.
We'll issue notice, let's see.
Very well, my lords. Also, in addition, if your lordships can, because I am only seeking for remand, my lords, a prima facie erroneous order is that my revenue entries are standing in my name and it has been revoked by virtue of the.
Keeping the office objections open. Let notice be issued. Office objection number 1. Of the note dated 24/4/2024 of the registry. Open, let notice be issued to the respondents returnable on. So and so accept notice for 2, 3, 4. That's right?
Yes, Malad. 2, 3.
2, 3, 4, let notice be issued to the other respondents returnable on.
In addition, if your lordships can permit me to serve on the council.
Additionally, liberty is granted to the counsel for the appellant to serve the.
Because a simple
counsels-
matter, my lords, I'm only seeking for remand. Under a confusion, this order has gone against.
How can we remand it without hearing them?
That's why, my lords, I permit.
It's one.
I will do it.
Liberty is granted to the counsel for the appellant to serve the counsels who appeared for respondents number 1, then 4-2, 1, then 5-2,
1 to 3 respond.
5-18.
Yes, please.
1 is there, then 5-18.
5 to 18 minutes.
The copy of the writ appeal
Very good.
and informing them about the date of hearing in this appeal.
Obliged.
20th September.
20th. Any shorter date possible?
Most shortest we have given.
Very good.
18.
Respondent statements.
What remains in this, anything survives?
Well, it's on the last occasion, additional parties were added as respondents. That is Commissioner of Police of Coimbatore City and Director General of Police of Tamil Nadu. Because my learned friend,
Service has been effective.
No, sir.
The service to the respondents, newly added respondents number
respondent number 4 and 5 minutes.
4 and 5 is still incomplete. Let fresh notice be issued for service on.
4 and 5.
See, what are your instructions?
Lord,
Have you filed the status report?
no, the detainee or the missing person is within the limits of Tamil Nadu. So the last time the order was made, we made an attempt to serve on the police there. They refused to take the notice, saying that let the notice come from the court. That's the difficulty we're facing. To coordinate with the Tamil Nadu police, the difficult task. So therefore, if the notice is served on them, my lord, on the last week, we went there to serve and take their help, but they would refuse. That's what the IO says. So the process is served.
But what are your investigations?
Lord, we could only go there since she was not available. The last track was that she was in some ashram there.
Where?
That what is that?
Isha Foundation.
Isha Foundation, Lord. So there are about 30,000 inmates there. We made an effort to track, but she's not there. So that's the last effort that we could make, and therefore Isha Foundation.
So now tell us one thing, what can be done in this petition now?
My lords, the petition is habeas corpus, my lord, writ petition. Petitioner is currently residing in Coimbatore. Children of the petitioner also residing along with him. The
What survived
missing
within the
detainee person was last known. Address was last residing in within the jurisdiction of this court in Anekal district. And FIR is filed, complaint is filed, and no investigation have been.
Missing
No
is-
status report has been filed, my lords, as of now.
Missing is no case.
No, the FIR is filed, there is a process which has been laid down. How can now an habeas corpus would survive? And now even 4 and 5 have been done, maybe it's a jurisdiction of the different high court. Merely because an FIR has been filed, that would not really.
My lords, that is a assumption that they are making, my lord. There is no guarantee that she is residing in Coimbatore or Isha, wherever my learned friend is saying.
Admission.
Please?
They have admitted something.
No, my lord, the submission which my learned SPP made now.
Question is this, my lord,
It is,
there is-
it is an assumption. There is no guarantee that she is residing in Coimbatore.
There is no illegal detention avowed in the petition.
None whatsoever.
Yes.
It
It's
said
only a
missing.
case of missing where
Missing.
habeas corpus would not lie.
My lords, I would beg to differ on that point, my lords, because the recent Supreme Court judgment passed in the year 2024.
He's not even a minor.
Yes.
No, my lords.
He's not a minor. How would now habeas corpus would now survive?
But page number, sir.
My humble submission is, my lords, in as far as the missing person is concerned, recent judgment of the Honorable Supreme Court in the year 2024 in Devuji Nair versus State of Kerala. Even in that matter, my lords, the detainee or the missing person was it was not a case of an illegal detention, rather it was of a missing case. In that, my lords, the Supreme Court has laid on few guidelines as to how a habeas corpus petition in case of missing persons needs to be addressed.
Well, the hidden
If
agenda.
permitted, I can submit a copy of the judgment.
He's moved a petition for divorce in Coimbatore court. Now he wants a divorce and therefore all these steps have been taken.
I beg to differ on that also, my lord, because
Admittedly, there is a petition. We have tracked that.
that petition for divorce is dismissed as withdrawn because there was a compromise that came through between the petitioner and the respondent.
He's suppressed that fact. Lord, all these things have been suppressed in the petition.
I have not suppressed. My lord may kindly see in the petition, I've clearly stated that they have been staying separately from the past 4 years.
But the petition which is moved before the court and that the settlement they have arrived at, Lord, case of missing is no.
What is the date of settlement?
Lord, I will place all that, Lord, by next week, Lord. There is a petition which.
File something on record so that at least.
Yes, yes.
The SPP states that he shall file a status report. We are recorded status report
Yes.
before the next date, 1 week before the next date of case. Give it in September, October.
17-9.
Please, ma'am.
Number 19.
Appear for the petitioners in this matter. I
I'll
request for
file
a
the-
pass-over minutes.
Second set to today itself, it's ready in my lap.
Just show us the file. Yes.
I just got done. The lordship permits me.
Kindly take it up matter day after tomorrow for final argument.
You are ready?
I am ready, my lords.
Start.
Please. I'm sorry, I was on my legs.
Second set. Objection statement, second set.
For the impugned order, your lordship will please find at page 36. Order, my lords, of the Debts Recovery Appellate Tribunal. Where, my lords, my appeal has been rejected on limitation. Against, my lords, an order of the Debts Recovery Tribunal, where also my application was rejected on the ground of limitation. In short, my lords,
Where is the DRT order?
please, my lords. DRT order, my lords, your lordship will please find at page
233. Your lordship may kindly see, my lords, there are two applications. One is at 233, the other is at 246. Your lordship may kindly see, my lords, 246.
What are the two applications?
My lords, the first application, my lords, at 233 was in respect of the possession notice. The application at 246 was in respect of the sale notice. It is, my lords, the second application that is carried into appeal. Because, my lords, by this time, sale has taken place. Here, my lords, your lordship will please see, my lords, it starts at 246.
The challenge was to the sale
Challenge was to the sale.
or the order passed by the for securing the property.
Lords, it initially, my lords, I bow down, my lords, the first application, that is the order at 233 was for securing the property. Page 246, that application was in respect of the sale. So far as the sale application is concerned, lords, your lordship may kindly see the reasons begin at page 254.
Is the auction purchaser here?
Second respondent.
You are the auction purchaser.
Reasons at 254, my lords. Fourth line from bottom, one single sentence.
Mhm.
Mention here that the tribunals have no power to extend the period of limitation on equity grounds. The rest, my lords, I can read the order, but it proceeds, my lords, on that basis that there is no power available at all to condone the delay. That is, my lords, the finding of the debt recovery tribunal. Of course, my lords, then
What is the basis for the tribunal say so?
lords, my respectful submission, not the honorable tribunal holds, my lords, that under the provisions of the Surface Act, there is no provision or there is no scope for condonation or delay. And my lords,
Let's see the appellate tribunal.
please. Page 36, my lords, is the order of the appellate tribunal. Lords, what I do, my lords, if I may just mention, from the order of the debts recovery tribunal, I prefer a writ petition before this honorable court.
Before, from the first order.
Please, my lords. Therefore, I do not directly prefer an appeal. I prefer a writ petition. The writ petition order, your lordship will please find at page 295. What's I impugn, my lords, the order of the debts recovery tribunal. And ultimately, this honorable court passes the order, my lords, at 299. The parties were directed to maintain status quo till the next date of hearing. Status quo was maintained by the parties till the impugned order is passed by the Debts Recovery Tribunal. Therefore, in light of the status quo being granted by the Debts Recovery Tribunal, I deem it appropriate in the peculiar facts of this case to permit the petitioners to approach the Debts Recovery Appellate Tribunal within 6 weeks from today, that is on or before 3/6/2023. In the event the petitioners would not file an appeal before the Debts Recovery Appellate Tribunal on or before 3/6/2023, the protection that is granted by directing the parties to maintain status quo would stand automatically vacated and the bank would be at liberty to proceed in accordance with law. In light of this order, my lords, I file an appeal before the Debts Recovery Appellate Tribunal. That I file, my lords, on 24/5/2023, before the date that is set for me by this honorable court. In this, my lords, your lordship may kindly come to page 39, where the discussion commences. As already referred to above, in the affidavit filed in support of the petition, no specific details are given for the delay except saying that the Honorable High Court granted time till 3/6/2023. Advocate for the bank submitted Honorable High Court granted time to petitioner appellant to enable him to approach DRAT, but it has not passed any order condoning delay. He submitted as per 18(1) of the Act, the appeal has to be filed within 30 days
from the date of receipt of order copy. And as the affidavit is silent as to the date of receipt of order copy, it has to be presumed that petitioner appellant received copy of the on the date of the passing of the order. Thereby, appeal has to be filed on or before 27/4/2023. In that light, my lords,
No, read further.
please. He further submitted that even according to his own affidavit of petitioner appellant, the appeal has to be filed on or before 27/4/2023, which indirectly indicates that the petitioner appellant received copy of the order on 27/3/2023 itself. Now, in the additional affidavit, the contention raised by the petitioner appellant is that time spent before the Honorable High Court has to be excluded under Section 14 of the Limitation Act. It may be relevant to examine Section 14 of the Act to decide whether petitioner appellant complied with directions imposed under 14 of the Act. Said section reads as follows. Then, my lords, 43. A plain reading of the above section indicates exclusion of time spent in another court bona fide. To apply this provision, petitioner appellant must establish that he prosecuted the matter before the Honorable High Court in good faith and with due diligence. Explanation to this section clarifies that when excluding the time, the day on which the proceedings was instituted and the day on which it ended, both shall be counted. So it is mandatory for the petitioner appellant to disclose the date on which he approached the Honorable High Court, but unfortunately nothing is stated in the affidavit filed in support of the application or in the better affidavit. The date on which writ petition is filed and the date of disposal of writ alone is referred to in the affidavit. As is seen from the record, it is not for the first time that the petitioner appellant has approached the wrong forum. In 2017, petitioner appellant filed essay number so-and-so and DRT dismissed such said application on 12/1/2018. After dismissal of said essay, bank issued sale notice for sale of scheduled property and appellant approached the Honorable High Court through writ petitions number so-and-so, challenging sale notice, and Honorable High Court directed respondent bank not to finalize the sale transaction subject to condition of deposit of ₹5 crore by petitioner appellant within the period of 6 weeks. But petitioner appellant did not comply with the said condition and the same is dismissed. In writ petition number so-and-so, the Honorable High Court stated confirmation of sale, and thereafter petitioner appellant filed an amendment petition to securitization application to implead the auction purchaser as respondent number 2. Petitioner appellant, on the advice of another lawyer, he filed a separate application challenging the sale notice. So these aspects would reveal that the petitioner appellant is filing cases one after the other and mostly after expiry of limitation. So conduct of petitioner appellant is also to be considered while deciding the delay condonation petition. Though the advocate for petitioner appellant submitted that a liberal view has to be taken in respect of condonation application relying on the judgment of the Honorable Supreme Court in so-and-so, the same cannot be accepted because taking liberal view arises when there is a genuine reason in not approaching tribunal in time. But here, as already indicated above, petitioner applicant is filing cases one after the other and every point of time he's pleading either there is delay or there is wrong advice. Further, 14 of the Act contemplates to fulfill certain conditions and without complying with them, requesting tribunal to apply the provision, in my view, is not a genuine request. Therefore, not entitled for the relief.
Yes.
Not my respectful submission, my lord, is threefold. Lords, so far as the Honorable Appellate Tribunal is concerned, this Honorable Court, my lords, gave me time until 3/6/2024. I filed it before that date. Lords, this Honorable Court is exercising jurisdiction under 227. In light of.
This is only to enable you to file an appeal. There is a date has been fixed. But that doesn't mean, let's assume for a moment.
Please, I filed it within that date.
Within that day, there is no dispute or no contest on that.
Please.
But is the tribunal precluded from, appellate tribunal precluded? Possibly you can seek the benefit of 14 that you were pursuing there.
Please.
Coupled with the fact that the single judge has granted you 3/6 date before which you have to approach.
Please.
Okay. Now let's assume for a moment, even before filing the writ petition before the court, limitation had expired.
Please.
Is the tribunal, you will get the benefit of 14 when you are pursuing before the learner single judge.
Please.
But if the appeal is barred by time even before you file the writ petition,
please.
Can the DRAT cannot look into it whether the appeal or whether the appeal before it would be barred by time because you are approaching the learner single judge was also beyond a delay.
I bow down, my lords, to what falls from this Honorable Court.
So let's see two orders.
Please.
The first order, which will give you cause of action, is the first notice taking possession.
Please.
The order of the learned, which commissioner or the district magistrate who has passed that order.
Please.
Let's see that 233. That's the point.
Please.
233. Is it 233?
Lords, one order is at page two
Ah,
thirty-three.
this. Now this 234
Lords,
is
this,
under, against an order under 13.4.
Lords, this order I have not appealed,
You have not
I have
appealed. So
not
we are out of this.
please. But they were passed on the same date. The second order, my lords, is what I have appealed.
Now tell us one thing.
Please,
In the absence of any challenge to this order,
please, my lords.
can you challenge the sale notice?
My respectful submission, my lords, I may still be able to, but my grounds will be limited to whether the sale was properly conducted.
That's right.
Please,
Okay, that it is whether sale has been properly conducted on.
please.
So to that extent, possibly cause survives. If you
Please.
have any grievance that a sale has not been conducted properly, you will.
And may I, my lords, in one sentence submit as to what is my case on merits there, only in one sentence. Lord, when I gave the property as a mortgage security, the valuation was 11 crores. It was ultimately sold at 6.58 crores. That, my lords, in short is my case. I will also refer to some correspondence in between.
So 21st of April 23 was the order. No, sorry,
27th of March, 2023.
7th of March 23. That's right.
Please, my lords.
When
Then, my
did
lords,
you-
on,
When did you approach the learned single judge?
lords, on 5/4/2023.
You were within time.
Please, my
Otherwise,
lords. In fact, the order is also within time. The order is on 21/4/2023.
so you say you got the benefit and the learned single judge has given you the time till the 5th of March to approach the tribunal. You went to before that date.
Please.
And pursued it, and the tribunal could not have rejected it
Please, my lords. That
on
is-
the ground of delay.
Please, my lords. One, my lords. Two, my lords. That was a time period, my lords, when our honorable court breaks on vacation, typically April, May. Perhaps, my lords, keeping that in mind, the honorable court said June is when courts reopen. Third, my lords, because this honorable court granted some indulgence, it was clearly, my lords, not a not bona fide petition before this honorable court.
Now, just tell us one thing, what
One-
the
one-
dates he was given.
One submission, Mike. Whether the first itself appeal before the debt recovery tribunal is maintainable, it was hopelessly barred by limitation. 45 days lapsed, my lord. Against that order, he preferred the writ petition. Thereafter, taken time from this,
No, let's see. Okay, these are the facts. Let's see,
my lord,
246.
246 page number
Now, 246.
is the
it's a challenge.
order they are challenging before the DRAT.
Oh, that's a sales certificate.
Sales certificate dated 16/5/2019.
16/5/19.
19.
And when did they approach?
They approached on 11/10/2019. Before the debt recovery tribunal.
No, but then 27th March 23.
See,
You
my
went
lord.
to the, you came to this court after the DRT passed an order on the sale notice.
Please, my lords.
Yes, my lord. They challenged the sale notice before this honorable court. They challenged the order of the DRT before this honorable court by filing writ petition.
They did not go to the appeal.
No, DRT. Apart from this, my lord, there are several writ petition filed earlier, and they are well aware that this honorable court has no power to adjudicate the matter. DRAT or DRT is the only court to adjudicate the aspect of section 17 and 18 of the act. Knowing fully well, they invoked the section 226 and obtain an order from this honorable court. In the first instance itself, honorable court also observed that this honorable court, however, they stated that since parties are settling the issue, we are entertaining. They have not settled. 5 crores, they are directed to deposit the amount, but that also not this one. Other two. Now, my lord, after nearly 4 more than 4 months. They have challenged before DRT itself.
Okay.
So
now-
DRT is the first application placed, my lord. They have no power to condone the delay. That's because in the main application DRT, that is observed by the Supreme Court also, that is observed by the DRT in their order. In its order, your lordship, regarding reasons why they are not condoning, they have no power. If the DRT has no power and held that it is a barred by limitation, question of DRAT does not arise, my lord. There also appeal may not survive. Mere, for example, for
Yes,
sending the appeal.
Just one,
Okay.
tell us one thing.
Please.
Your challenge to the sale notice was actually barred by time.
Barred by time.
It was, my lords,
Yes, sir.
beyond time, my respectful, it was, my lords. But there are two factors, my lords.
Pardon?
It was, my lords, it was. It was. But there are two factors, my lords, why in my respectful submission, I was entitled to a consideration of the reasons.
That's right. But in any case, so that was barred by time. You went to DRT.
Please,
The DRT rejected your application.
on the ground that it is barred by time.
Then maybe within time you have approached this court, within that 30 days, you have
Please.
approached this court.
Please, my lords.
So the court had granted, say that till 3/6 you can go.
Please, my lords.
What we had put to you earlier is the same.
Please, my lords.
If your earlier appeal was barred by time,
Please, my lords.
to the sale notice,
Please, my lords.
to the sale
Then,
notice,
my lords, then I have no legs.
and nothing precludes the appellate tribunal
Please,
to
my lords.
look into the fact that, see, what is tribunal is testing? The tribunal is testing the order of the DRT.
Please, my lords.
You got a recourse through the order of this court.
Please.
To file the appeal within time, but nothing precludes the appellate tribunal to consider the order passed by the DRT, whether it was right or wrong.
I bow down, my lords.
So DRT says it was wrong. It was belated.
What's
DRT says belated.
DRT says it was belated.
That's right.
The appellate tribunal does not categorically deal with that issue at all. The appellate tribunal, my lords, largely proceeds on the premise that
On
I have come
14.
late there
On 14.
on 14. Therefore, my lords,
But
whether,
tell us what was the reason before DRT?
lords, the reasons before the DRT, my lords, were multiple, my lords. One, that there were, my lords, a series of writ petitions at page 143, my lords. There was, my lords, a securitization application that was already pending. In that, I first moved an amendment application at page 143. Then I realized, my
What
lords,
was that securitization application?
that was against possession, my lords, which has now attained finality.
That 13-4.
13-4. I moved, instead of challenging the sale notice directly, I moved an amendment application to an existing petition. Then, my lords, on better advice, I filed a separate application.
When did you file that? When was the order of the 13-4?
The order of 13-4. No. The order of 13-4.
9/8/2017 was the date of possession notice.
Pardon?
9/8/2017.
9/8/2017.
Possession notice was.
Please,
When did you file the appeal?
lords,
Now,
The-
no, 1 minute, we are sorry.
please,
So this is 9/8/2017.
please, my lords.
Okay.
Please, my lords.
Now, this order is of the possession.
Please, my lords.
This order was challenged by you
It was, my lords.
in, on which date you filed
On
the,
3/10/2017.
this is against the possession.
Please, my lords.
Sale notice was on which date?
Sale notice, my lords, was on.
7/3.
No, my lords, I will just submit it. Sale notice was on 16/5/2019.
16/5/2019.
Please, my lords.
Okay. When did you file the amendment application?
Not amendment application date, I do not have, my lords. I've left it blank.
Oh, that's important.
Lords, then, my lords, your lords, I will make one further
Now,
attempt.
this amendment application, when was it withdrawn?
Lords. The amendment application,
You withdrew it, no? You
There is-
withdrew it or it was dismissed?
lords, lords, we simply filed a separate application.
No, but we got the impression that you filed an application for amendment.
I filed, my lords.
When
that
is that?
Lords, that application is at page 143. But my lords, the date, lords, if your lordship permits me, my lords, as to what happened to this amendment application, I will have to find out.
No, we want to know the date.
Lords, this date.
6519.
Lords, it says 6519, my lords, but in my list of dates, I have left it blank because I don't have a certified copy and I am not certain, my lords, about this date.
It cannot be 6519. Because the sale notice was 16519.
16.3, 16.5.
So it cannot be 65.
Oh, there are multiple, is it?
My lord, what happened is, was he filed application for amendment and requested the court to club the both cases. Simultaneously, both cases without passing any order on application for amendment. And both cases clubbed and heard together and disposed of, my lord. That's it.
The order of the DRT.
Yes, my lord, DR, before D.
See, your application could not have been post sale notice. This amendment was not because of sale notice.
Lords, there were,
It could not have been.
please note, there were,
Because
please,
sale notice is 16.5.
please.
You
note.
filed it much prior to this.
Please.
Or 6.5.
There were multiple sale notices, my lords. That's all I can say in my
He
defense.
challenged each and
Doctor-
every stage, my lord, this.
For example, my lords, 126 is a sale notice. This was 20/02/2019, the date of the sale notice. Sorry, possession. 27/2/2019 at page 127.
But where is the amendment in your application for amendment
Please,
with regard to sale notice
I will show that.
16/5/19?
Please.
16/5/2019, the sales certificate, my lord.
Or sale certificate?
Sales certificate date.
Page 149, para M, if your lordship will please see.
Now then, what was the date of sale notice?
27/2/2019.
27/2/2000.
19.
Okay, now this is what you wanted to amend it.
Please.
The reason for amendment was this 27/2/19.
And my lords, if your lordship will please see page 149, para M.
What is the period within which you could have challenged the sale notice?
45 days.
45 days.
Please.
So you could have only filed before 15/5/19.
Please.
Getting the point?
Please, my lords. There is a
15.
delay, my lords.
15/5/19, you
Please.
could have filed it,
Please, my lords.
45 days.
Please, my lords.
And that was this 6/5 which you filed it was much beyond that.
It was beyond that. my lords.
So then how would you answer?
Please, my lords.
Your very application for amendment was beyond time.
Lords. There, my lords, my respectful submission is that a delayed application is not barred. There is, my lords, a power to condone the delay because, my lords, the period of limitation is not closed. And, my lords, the record will reveal, my lords, that there were multiple applications before the Debt Recovery Tribunal, before the Honorable High Court.
Power to condone is where?
My lords, section 17(1) simply says, my lords, that tribunal having jurisdiction in the matter within 45 days from the date on which such measure had been taken. There is, my lords, unlike, for instance, the Arbitration Act, which says delay can be condoned, but not beyond a particular time period. There is no such restriction.
But then that is something, will it come to your favor as compared to 34(3)?
Not in my respectful submission, lords. There is a judgment,
There
lords.
has to be a specific
Not-
clause for condoning with.
One judgment, my lord, will your lordship kindly see? Judgment of the Honorable Supreme Court.
No, let's read on a reading of the provision, there is no power to condone. Let's be clear.
Please, my lords.
Right?
there is no specific power to condone. But my lords, may I submit respectfully? There is, my lords, no specific bar on condonation. My lord, will your lordship kindly see section 18 also of the act. Section 18 of the act is the provision for an appeal. Section 18 also, my lords, in terms of language is similar. Within 30 days, there is no specific provision. Not section 17. Any person including borrower aggrieved by any of the measures referred to in subsection 4 of 13 taken by the securitator or his authorized officer under the chapter may make an application along with such fee as may be prescribed to the debts recovery tribunal having jurisdiction in the matter within 45 days from the date on which such measures had been taken.
Which one you are reading?
I'm sorry, my lords. Section 17, subsection 1 of the Surface Act.
That is for 17 against the sale notice.
Please, my lords.
Against sale notice.
Please, my lords. This is the provision.
Now tell us one thing.
Please, my lords.
Did you challenge the sale certificate?
Lords, I have, lords, the order at.
See, sale notice is one, sale certificate is other.
Please, my lords.
Both are different.
Please, my lords. Page 205 is my prayer. Say, overbroad prayer, my lords, but says entire measures initiated by respondent under 13 of the Surface Act.
Even this is barred by time.
Lord, this is my respectful submission, my lord.
So the sale certificate is 16/5/19.
Yes, my lords, it is.
So 16/5/19. And thereafter 45 days, let's assume for a moment, this is not even 45 days.
11/10,
45 days. This is 45 days.
11/10/2019, he filed that way.
That's right. So 16/6 plus 15, 1st of July.
Please.
And this you have filed on 11/10.
Please, notes. There is delay. There is no.
Then where is the power?
Notes on that. On that, will your lordship directly see, my lords, a judgment of the Honorable Supreme Court under section 18, of course, of the Surface Act, where various issues, my lords, were raised as to whether there is
We
even.
are not on 18.
I understand.
We are on 17.
I understand, my lords, which is why I start by saying it's under 18. My submission to your lordships, my lords, is that 18 and 17 are structurally similar. They may not be pari materia, but in terms of whether provisions of Limitation Act will apply, whether an application for condonation of delay can be made, whether section 14 will apply, they are similar. And my lords, they are, will your lordship see, my lords, for a moment, section 24 of the DRT Act.
Where is this Kerala High Court judgment on which the learned DRT relied upon?
What's that? Lords, I will get that, my lords, if your lordship will give me some time, my lords, I will get that.
If you see, page 255,
Please, my lords.
AP Jayan and Hong Kong Shanghai.
I will produce that, my lords. Your lordship may kindly give me some time, my lords, because there is a,
Let's see which is the judgment you are relying.
please. My lords.
Which is the best one?
Lords, judgment of the Honorable Supreme Court, page 8. First para at page 11. Question in this batch is whether the appellate tribunal under the act has the power to condone delay in filing an appeal under 18(1) of the said act. And my lords, the conclusion is that power is there. But my lords, there are various caveats in the judgment, but the conclusion is that power resides. Para 3.1, my lords. Section 18(2) of the Act provides that the appellate tribunal shall follow the provisions of the RDB Act in disposing of the appeal unless otherwise provided under the Surface Act or rules made thereunder. Thus, the proviso to 23 of the RDB Act empowers the appellate tribunal to entertain an appeal after expiry of period of limitation if sufficient cause for not filing an appeal within the period of limitation is shown. Thus, the proviso to 23 is incorporated in 18(2) of the Act.
But the Supreme Court was only considering the appeal provision,
Please, my lords.
not the initial
Not the
provision
original.
under 17.
Please, my lords.
Now, this is
Please,
for the reason
please, my lords.
because 18(2) specifically states refers to RDDB Act,
Please, my lords.
right?
Please,
Unlike 17,
please, my lords.
17 when it refers to limitation,
Please, my lords. Lords, will your lordship also please see, my lords, section 17, subsection 7. And then, my lords,
let's see the facts.
please, my lords. For completion, my lords, will your lordship kindly see section 24 of the DRT Act once, or I'll just read it out. A very small provision. The provisions of Limitation Act shall, as far as may be, apply to an application made before a tribunal. The language, my lords, is application. It's an application under 17, it's an appeal under 18.
But how much far one can go to condone the delay?
On that, my lords, my respectful submission.
It is 10 days, 15 days, on a principle of law, Supreme Court holds.
Please,
Is it possible?
please,
Is it between 30 days and 45 days the delay can be condoned? Or
please,
is it beyond 45 days also condoned, delay can be condoned and minded?
please,
If it is beyond 45 days,
please, my lord.
then how much? Is it infinite? Anything? What would be your?
Not on that, page 68, delay of 249 days was condoned.
Pardon?
Page 68, my lord, say division bench of the Honorable Delhi High Court condones delay, approves, my lord, say condonation of 249 days. May I read from para 4, the facts that came there. After 249 days, the petitioner filed the aforementioned essay against the consortium of banks before the DRT, along with an application for condonation of delay, claiming that an excess amount had been recovered from it and that therefore a further sum ought to be recovered from it and therefore a further sum ought to be returned to it as residue of the auction proceeds. Initially, the application for condonation of delay was rejected by DRT by an order dated so and so, holding that DRT had no power to condone the delay. Said order was assailed by the petitioner in appeal before DRT. By an order dated so and so, the DRT remanded the matter to the DRT to again consider the application for condonation of delay. On remand, DRT for a second time held that sufficient reason had not been shown by the petitioner. Accordingly, it was held that essay was barred by limitation. Against the said order, petitioner once again approached DRT. By the impugned order, DRT has, while dismissing the appeal, held that essay itself was not maintainable before the DRT. This court has heard the submission of so and so. Then, my lords, ultimately, order is set aside.
See, I think you file your submissions on, this requires consideration.
Please.
We look into this.
The-
File your submissions. Counsel for the parties to file their written submissions along with the judgment they want to rely on. Within how much time?
2 weeks. 2 weeks.
2 weeks.
Let the auction purchaser not create further third party rights.
See, we say nothing, we'll hear it.
Please.
That's all.
Very
We'll hear it.
Very good. So great.
18/9.
Now you appear for the bank and you appear for the auction purchaser. Is he a party here?
Yes, yes, ma'am.
File your submissions.
Please.
Yes.
20, my lord, this case, my lord. The appeal is against the appellate tribunal and wherein the
Just give us.
appeal was allowed by the appellate tribunal filed by the respondent on the ground that the accused number 1 was acquitted. Now, my lord, subsequent event is there, my lord. They have filed a discharge application before the special court that was allowed. And against that, before the High Court, we have challenged. That was allowed, and again, the respondent approached the Supreme Court, my lord. There, my lord, they have confirmed the order of discharge. So,
Of discharge.
please, ma'am. Now,
Why this, Mr. Shetty?
does not, sir.
In fact, we wanted to ask you what happened to the, see, there is a batch of appeals. If you see the impugned order,
Yes, my lord, that they are all,
what happened? This is only in one appeal they have filed this.
please.
You have filed it.
No, others are there, my lord. I will, because in that, my lord, some are dismissed for default. We have filed a application for recalling.
But now only in so, is it common in all the appeals? Discharge?
Not no.
Only in
Only,
this?
only,
Only in this?
in the respondent as well as her son, my lord, in this case.
So which is this appeal? Tell us.
This is 83, my lord.
Hmm?
83 is,
No, if you see page 16,
please,
this is in batch of matters, no?
please, my lord.
Parvati Shankar Kullu. Where is
That is the
Parvati?
respondent hearing.
That's respondent. Which proceedings before the?
That is 3, my lord. In page 13 mechanisms.
Three.
3.
So 3 would be now.
Disposed of.
You will withdraw this.
Infructuous it may be in way of the judge.
Just say, where is that? What have you filed?
Now, Supreme Court judgment.
Where is that? Discharge there in the criminal.
Order of discharge has been confirmed by the Honorable Supreme Court.
Mr. Shetty on the council appearing for the appeal states that the present petition has become appeal has become infructuous for the reason that the respondent herein has since been discharged
Please,
in the predicated offense.
predicated offense, which has been confirmed by,
Has been confirmed by the Supreme Court.
Yes.
In special leave petition, special leave.
4258.
Criminal.
4258.
Of 2021. Decided on 16/8/2022.
22.
In 22. Stop. He states, he has placed before us the copy passed by the Supreme Court. In the aforesaid appeal. Full stop. The same is taken on record. In view of the aforesaid position, Mr. Shetty states that the petition appeal be dismissed as infructuous. It is ordered accordingly. And just note it down. Yes, yes.
Lord, I appear for the respondent. Lord, I am a special counsel. My name has not been shown in this. Could your lordship direct the office to show my name and kindly, my lord, this may be posted on Wednesday, my lord. I seek for a short accommodation.
Even my kind submission.
What happened before the appeal?
Lord, the appeal is still pending consideration.
Oh, it's still pending?
Consideration.
That's right.
Matter
Is it
went up to
pending?
the Supreme Court. Supreme Court
before the single judge, one Supreme Court order has been considered. Another Supreme Court order is there, recent one.
The appeal is still pending.
Pending, my lord. Wednesday, could your lordship kindly have it? So and so appears for you appear for the respondents? Yes, my lord.
1 to 4.
My lord, 1 to my lord. In appeal number 569, I appear for 1 to my lord.
7.
7. What remains in this petition appeal? Who is?
May,
for the
may,
peti- who
may,
is-
I'm applying, please.
You are the appellant and you are appearing with him?
No. Is for
separate.
respondent.
So what remains in this appeal?
Is there, please?
Yes, we are putting it to you. What remains?
One more Supreme Court order is there, please.
Huh?
One more Supreme Court order is there. Thereafter, Supreme Court has passed one more order.
Where is that? That he has not placed before the learned single judge, my lord, when the matter was taken up before the learned single judge. We want to see where is.
263. 263. Before that, please come. Kindly see page number 57, please. 57. Per moment. All this vital document has not been considered by the 57. Annex H 57, page number. Kindly come to page number 58, para number 3.
These are criminal proceedings.
Yes. No, an inquiry report was submitted.
Sir,
No, one minute. The investigation report itself has produced and court held that there is no error in the caste certificate. Against this, they preferred appeal before Supreme Court. Kindly see page number 263. 263. State is a party. The appellant before the appellate tribunal authority is a petitioner before the Supreme Court. The relevant statute has not brought to the notice of the Supreme Court. The caste validity certificate issued in 2005 has challenged in 2010. The appellate authority does not have.
at the request of counsel appearing for the appellant, for the respondent number.
5.
Here for 5.
No,
Lord,
1 to 4 is for official respondents, special counsel,
Is a special counsel. Okay, 1 to 4. Who appears for 5?
private respondent.
No, notice issued, ma'am. Let notice be issued to respondent number 5.
In second one, respondent number 8. 1 to 7, he will appear.
No one appears for respondent number 5. Let fresh notice be issued to respondent number 5. And in the other one,
Respondent number 8.
respondent number 8. Returnable on.
Special counsel name has to be shown.
C. Jagdish.
Special counsel.
One submission, please, Madam. I have to produce some more documents. They are part of the petition. Can you permit it, please?
File along with an application. The name of the special counsel. Mr. C. Jagdish be shown in the list, pause list. Next. Oblige.
Serial number 22.
But sir, I undertake to file wakalat for respond number 1 in this case because
Wakalat is ready. The file it notes during the course of the day. Your Lordship, this is
Appears and states that Wakala shall be filed on behalf of
respondent number one, my lords.
respondent number one. Who appears for the others?
Notice has been taken by the government advocate.
Notice has been served. All have been served.
Yes, your lordship. Your lordship, there's an urgency that the stay may be granted for the survey.
We notify.
Before 9.
IA number 6, there's an urgency, your honor.
We have
The
given
survey
the date. We'll hear you.
Serial number 23.
There for the respondent 1 and 2.
For the petition, we
Yeah,
have complied with the previous order granted by this honorable court. We have challenged the auction sale notice. This honorable court was pleased to directed me to deposit 20 lakhs. We have complied with that order. In any of the contentious issue involved, they are required to file the reply. My learned friend.
There
has-
for 2 weeks, my lord.
You appear for bank.
For respondent 1 and 2, my lord. Yes, my lord.
Bank.
Yes, my lord.
Now what is the liability?
Liability, my lord, as on today, 50 lakh 70,000 rupees. Now they have deposited 20 lakhs before this court. I pray for 2 weeks' time to file my statement of objection, my lord.
The sale has been effected.
No,
It has been affected, yeah.
Certificate.
Not yet, my lord, not yet issued.
The auction purchaser is here.
No, my lord.
My learned friend has also proposed for some sort of settlement. We are going to talk today itself.
At the request of counsel appearing for the respondents 1 and 2 bank to file objections
Yes, my lord.
to file objections from a re-notify. The objection shall be filed within 3 weeks, rejoinder within 2 weeks thereafter.
24/9.
Interim order may kindly be extended.
Interim order if any to continue.
Much.
Serial number 24.
Lord, serial number 24 and 25 and 26. How to put on?
35.
My lord, serial number 24, 25 and 26 are connected to serial number 35, my lord.
You are ready? Okay.
Everything.
My lord, one submission, my lord. The coordinate bench has passed these orders. And you see this. These matters have to be posted. There is another matter is also there that has not been listed. For final hearing, it may be posted for 1 date. It is admitted and rule is issued.
Matter at serial number 35.
Wait. Let him know. Another what is another?
But how the inquiry proceedings are going on?
Lord, it is stopped, my lord, because of the interim order granted by this
But
honorable.
the tribunal has set aside now.
Lord, the charge sheet was quashed by the.
So I raise the question of inquiry. Was any stay given by this court?
Lord,
Originally, yes. Originally, I challenged the articles of charge before the tribunal. Tribunal did not grant me an interim order, against which I came in writ petition. This court, my lords, granted an interim order by a detailed order, which was challenged by them before the Supreme Court, my lords, which was not considered favorably. The Supreme Court remitted back to High Court. High Court remitted back to CAT. CAT now, my lords, has passed the final order in my favor.
Setting aside charge sheet.
Lord, what has happened, my lord, while they're remitting the matter to the tribunal, to this honorable court, the Supreme Court said, with regard to the maintainability of the writ petition was also questioned. That was the observation of the Supreme Court. Be that as it may, my lord, Now these matters have to be listed for final hearing. All these three matters are posted today, and serial number 35 is there. These three matters have to be connected to 35, and another matter is also there.
All right, whatever will be the outcome will follow there.
Yes, madam.
You are the councils,
Yes, we are the
in
council.
all the matters,
In all the
you
matters.
can argue.
Then, my lord, say
Can imagine if there is a third council who has to be heard, but you
Yes.
are the council.
we'll have the one some other day, my lord, because I have to have that matter also, which is filed and it is before the registry.
Which matter?
There is another matter connected to this.
It will not make any difference on a pure question of law.
Yes, madam. We'll have it any other day. It may be fixed for final hearing.
The request of council appearing for the petitioners herein, we notify on.
18-9,
They need it.
18-9.
Who has moved this thing for listing?
My lord, boosting means because these three matters were not connected to the original matter.
Original matter is at 35 minutes. All these, the orders here only say because of disposal in that, these applications are disposed. That's
All right, we'll adjourn it. You get it listed on that day or not?
Yes, we will argue the matter.
come back to your lordship. 12-9. 12-9.
18-9, sir.
80. Great.
There is another matter also, it has to be connected.
We say nothing. You move according to the process.
Yes, madam.
We say nothing.
Yes, madam, please.
Bless.
Much okay.
Yes.
27, Shri Manivannan.
On the complaint of the respondent number 4, my lords, stating that the petitioner said to have encroached an extent of 2 gunta in survey number 15
Is a
bar.
connected matter also? There are two matters.
Yes, my lords. Both my lords. Similar set of facts. The order remains the one and the same, but different as against the petitions.
But the subject matter allegations are same.
Please, my lords.
Same survey number, everything land
Please.
same.
Please.
Yes, what do you say?
Now, my lords, the claim of the respondent number 4 as a complaint before the lower court, that, my lords, we said to have encroached. Now it claims, my lords, there is a cart way. Now, actually, my lords, no documents placed before the court, that is the server records at least, to show that there is a cart way. One. Second thing that, my lords, now the trial court has considered this, the B Karab land itself as a way. And actually, my lords, now whether there is a pathway or the cartway. Now, as according to this, the Google search, my lords, the pathway measures only 8 feet width. And this, the cartway, it measures 20 feet. One. Second thing that, my lords, we have not at all encroached that. That pathway even remains as it is now. And with regard to that, this, the respondent number 2 himself places a photographs, which clearly shows that the market exhibit P13 and 14. And now, my lords, all that the respondent number 2 places.
Yes.
And all that, my lords, the respondent number 2 E places the documents from the Tahsildar who Satta have issued a report to him, one, and the rough sketch. And the authors of these 2 documents are not summoned or proved these 2 documents. And those are the material documents on which the Honorable
Yes.
Yes, my lords. Now, my lords, exhibit P10 and P11 are the sole documents for the Honorable Trial Court to convict the petitioner for imprisonment of 6 months as well as the imposing a fine amount of 10,000. And the authors of these 2 documents are not summoned.
Have you filed the translations of Kannada documents?
Please, my lords, already filed.
Where are those?
Yes, my lords, translated copy for this page number 92, my lords. 92. A report of the Tahsildar, my lords. The Tahsildar not at all summoned to prove this document.
Where is the translation of page 37?
Yes. Evidence. Page 118 minutes. Process. Sorry. Sorry, minutes. Page number 26 minutes. 26. 1.
2?
76. 76.
76.
76. Examination in chief of respondent number 2. It commences from 74 minutes. 74.
Where is exhibit P11?
Please. Yes. Yes. Page 95. That is a sketch, my lords. It shows that this respondent number 2 also said to have encroached. He is the holder of SR number 24/1, which is consisting of 5 gunta B Karab, and he also said to have been encroached that. That is a rough sketch, my lords. It is not an authenticated, no survey record. No such authenticated survey records are placed before the trial court.
Is the complete record here? Complete record may not served. Complete record may not served. Apart from that, my lord, the Tahsildar report, lord, was the only report is my lord, is placed on record. The report is not, only letter, my lord, is placed on record. The report is not placed on record. When the Tahsildar went to the my lord, spot, my lord, the accused, my lord, the attacked on the Tahsildar. My lord, subsequently, my lord, the report was admitted by the my lord, the accused before the my lord, court. This respondent number 2 is the complainant.
Yes, ma'am. He is also holder of SR number 24/1.
Issue notice. We'll have it before 30th of August.
My lords, there is a bail order granted by the court below only to till 14th.
No, not 14th or 30th.
Yeah, 14th.
30th. See that impugned order.
Page number 194, my lords, order sheet is placed.
$60 days. Just say this, issue notice. Issue notice to so and so accept notice for one, let notice be issued to respondent number two. Okay, subject to the appellant furnishing bail bond in the sum of rupees 50,000 with one surety, comma, there shall be stay of the sentence, stay of the sentence in till the next date of hearing, the subject to say this, there shall be a suspension of the sentence in, what is the appeal number, the criminal case number?
Yes. 1981 of 17, my lords.
P number 1981 of 2017. This is to the satisfaction. To the satisfaction of the court, to the satisfaction of the, which is this court?
Land grabbing prohibition court, my lords, Kotal 2.
Karnataka Land Grabbing Prohibition Special Court at Bengaluru. Court hall number 2. Till the next date of hearing.
Please.
The you will produce the complete record. The counsel for the appellant, have you filed the complete record?
Yeah, we filed, my lords. Whatever that they placed, all that we filed in this.
Whatever there below, have you filed it?
Yes, my lords.
Okay, then we say nothing. List on. Give it in.
Report is, the Tahsildar report is not placed on the record.
No. Exhibit P10 we placed. That is the report. Exhibit P10.
Let the trial court record be requisitioned before the next date of hearing. Let's give it in September.
In connected matter, my lords, case number change.
The case is only different.
Yes.
Same order in the next one.
Case number 182 of 2017, my lords.
1 minute. You deposit the fine amount.
A fine amount 10,000 rupees deposited.
The next case also subject to this and subject to the appellant depositing the fine amount with the Registrar General of this court within 2 weeks. Okay. Subject deposit before the court concerned, that is the same Karnataka Land Grabbing.
My lords, we have already deposited 10,000 rupees fine amount, my lords.
You have deposited?
Yes, my lords. Subject to that only bail has been granted.
Then cut it. Then cut it.
In another matter, my lords, only case number changes.
20359.
Yes, ma'am.
That is also same.
Same, my lords.
But the only case number is different.
Yes, my lords.
198.
So this 4-1 is this. No. We have given 1981, the case number. 1981. No, the LDCP. The other one is 1982. Number one.
Six, nine, sir.
Please.
And this also. Next.
Serial number 29, Shri Narayan Bhatt.
Appear for the petition. My lord, this is pertaining to payment of pension, my lord, for the services that I had rendered in the IB for 10 years and 11 months. My lord, when I was working in IB, my lord, I submitted 3 applications through proper channel. One, my lord, to the LRD, another, my lord, to the ITI, and my lord, the third was for the employed ESI, Employment State Insurance Corporation. My lord, first I was selected in the LRD, which was under the Ministry of Defense, Government of India. My lord, I was relieved with a lien, my lord, for a period of 2 years. When I was working in LRD, my lord, immediately.
What is LRD?
Licensed Radar Development Establishment.
Is it a pensionable service?
It is a pensionable service.
Then you came to?
Then I came to.
ITI.
Then, no, my lord, I once again came back, my lord, to the IB.
Okay.
I worked there, my lord, for 1 day. Technical resignation submitted, I joined ITI. ITI is a non-pensionable service. When I was working in ITI, my lord, I got selected through the UPSC, through the application, my lord, which I had submitted through proper channel in the ESI. I got relieved from ITI and my lord joined ESI.
How many months you worked in ITI?
ITI, my lord, 4 months. That was a non-pensionable service.
See, the difficulty is there only. It's not a continuous pensionable service.
My lord, I am not claiming any pension, my lord, after I left IB. Only for the IB service, my lord, I am claiming pension.
No, but 10 years, where do you get pension? How, under which rule?
My lord, under Rule 37, my lord.
Rule 37 is on absorption in PSU.
Yes, my lord, I was absorbed. My lord, absorption is the date of joining.
Which PSU?
My lord, that is ITI.
You were not absorbed. You resigned from ITI?
My lord, I was absorbed, then I resigned.
That's right. So resign will entail forfeiture.
My lord, it will not forfeit, my lord, my past service.
Okay. Let's see this way. ITI, if it was a pensionable service, you were absorbed. Possibly you were right in saying that service need to be counted, IB service need to be counted for the purpose of granting pension.
Yes.
You can argue that.
Yes.
But it's not such a case here. It's a case where it is not a pensionable.
It is not a pensionable service. So, my lord, the moment I join ITI, my lord, I get pension. My lord, which during the first round of litigation, my lord, the IB also admitted. My lord, may take your lordship, my lord, to the.
No, what have they admitted?
That, my lord, I am entitled to pension for the IB service.
So why are you bringing in ITI? Don't bring in.
I am not bringing ITI at all, my lord.
Bring it. So your case is on the strength of service put in by you of 10 years and so months.
Yes, my lord.
You are entitled to pension or certain benefits which you are otherwise entitled to for that service.
Exactly.
Now we are putting it to you for 10 years. Are you entitled to pension?
Yes, my lord.
Now where is your prayer before the tribunal?
My lord, your lordship may kindly turn to page 53, my lord. My lord, before taking your lordship to the prayer, my lord, may I just point out, my lord, what transpired during the earlier round of litigation, my lord.
See your prayer C.
issue a writ of mandamus or any other appropriate writ, order or direction, directing respondent 2, 5, and 6 to pay pro rata. My lord, that pro rata pension and gratuity having regard to the 10 years and 11 months, 3 days service
How did you leave IB? On technical resignation?
on a technical resignation.
So technical resignation, did you get anything from IB when you left?
Pardon, my lord.
Did you get anything?
I did not get it.
So would not resignation forfeit the past service?
No, my lord, if it is technical, it does not.
Now, what are you entitled to for that 10 years of service?
My lord, I would be entitled to pro rata pension for the 10 years.
Under which rule?
My lord, rule 37.
We'll come back after lunch.
Number 31, my lord.
Pardon?
Final 31, my lord, serial. number. I pray for a week's time, even opposite side also there.
For respondent in this matter, Your Honor.
I have to file objection to their application. They have filed an interim application, my lord. That objection is ready. I'll file it in the
And this for
council.
final hearing, Your Honor.
This is for additional documents.
Not addition.
Application is what?
Application they filed for modification of some interim order
Interim
which was
order.
passed by the chief justice. my lord.
We will see, let's see that. Let's take up the appeal,
Yes.
let's see.
Uh,
We'll come back.
I am going to file an objection statement to the counter. my lord.
Look into that. Let's see that. Let
Yes,
us
ma'am.
come back.
Number 34, my lord. My lord, it's for final consideration, but the notice to the private respondent is not yet ordered.
The private respondent is the
One and two.
the
One.
petitioner.
The petitioner in the writ petition.
They are not represented.
No, the notice itself is not ordered. The order sheet doesn't show that it is to be ordered.
We'll just come back after lunch. Yes.
My lord, I had put in 10 years and 11 months of service is not in dispute. I submitted my application, my lord, through proper channel. My lord, I submitted technical resignation to IB and joined ITI. My lord, now I request your lordship to kindly see, my lord, Rule 37. A government servant who has been permitted to be absorbed in a service or post in or under the corporation or company wholly or substantially owned or controlled by the central government or a state government, or in or under a body controlled or financed by the central government or a state government, shall be deemed to have retired from service from the date of such absorption, and subject to Rule 3, he shall be eligible to receive retirement benefits, if any, from such a date as may be determined in accordance with the orders of the central government applicable to him. Then, my lord, sub-rule 2, explanation. Date of absorption shall be, in case a government employee joins a corporation or company or body on immediate absorption basis, the date on which he actually joins that corporation or company or body. In my case, my lord, this is applicable because I had no lien, my lord, in IB once I joined ITI. It was a technical resignation and there was no.
Where are you absorbed? You are not absorbed.
My lord, I joined.
See, absorption presupposes you have come on deputation. That's not the case.
My lord, it is only to LRD. From LRD, I came back to IB. From IB, my lord, I tender my technical resignation and join ITI. ITI is a corporation.
ITI is not by way of absorption. ITI is by way of a direct recruitment.
It is a direct recruitment.
Open selection.
Yes, my lord, it is an open selection.
That's not these 37 contemplates. 37 contemplates, you are in a pensionable, you have come to a public sector, got on deputation, then absorbed.
My lord, that is 2, my lord.
That's not the position here.
That is not 1, that is 2. Your lordship may kindly see that.
C2.
In case a government employee initially joins a corporation or a company or a body on foreign service in terms of retaining a lien under the government, the date from which his unqualified resignation is accepted by the government. If it is a lien or deputation, my lord, it is 2. Otherwise, my lord, if I directly join, my lord, it is 1.
So you did not get the benefit of 10 years.
I get the benefit of 10 years, my lord.
In IB, you did not get.
I got, my lord, they admit.
What did you get?
My lord, I have worked in IB for 10 years and 11 months, which is not in dispute.
But what did you get? What benefits you got?
I didn't get anything. That's why, my lord, I was before.
What is the pension? Where is the stipulation for pension for 10 years?
My lord, your lordship gets that Rule 49, my lord. That the IB admits, my lord, in the earlier round of proceedings. What it says is that, my lord, I cannot claim, my lord, the service rendered thereafter. After resigning from ITI, I had joined ESIC, then thereafter EPF.
They are right that way.
That, my lord, I may not be entitled.
Right. You would not be entitled to, but the only thing you should argue is this. Having allowed you to technically resign for joining ITI, the benefit of, and which is not pensionable.
Yes, my lord.
The benefit of 10 years must accrue to you.
That's my submission.
That's all you should say.
Yes.
Where is 49?
49, my lord.
Amount of pension.
Yes, my lord.
Now their objection would be that you have not retired.
I have not retired.
So this 49 would come into play when an officer, a government employee retires.
Please,
Not resign on getting there. Getting the point?
please,
It is not a case of retirement.
this is not a case of retirement.
It's a case of technically resigning,
Please,
taking the job.
exactly, my lord.
So if that be so, how would you answer it?
Your lordship may kindly see another rule, my lord, rule 26. That is 26 last sub rule 7, my lord. A resignation submitted for the purpose of rule 37 shall not entail forfeiture of past service under the government.
Yes.
My lord, the learned tribunal,
Although it is 37 strictly doesn't apply to you.
my lord,
You can still argue that once you went to ITI and that process was through normal channel, proper channel,
yes,
and they have, where is the acceptance of technical resignation
pardon me.
by the IB? Where is the acceptance of technical resignation on your joining ITI?
My lord, I was relieved. That order, my lord, is with them. I don't have that. I was relieved.
How were you relieved? Where is your, how did you came out from IB? What was the letter given by you?
My lord, my application was through proper channel.
Sorry, but how did you go after you got appointment? How did you got yourself relieved from IB?
My lord,
See, your whole case is you are technically resigned. Where is the document to show you technically resigned?
my lord, the document is with them, my lord.
Where is your request? Show us that request.
My lord, I only produced, my lord, the letter of appointment.
We want to see how did you got yourself relieved from IB? We want to see that.
My lord, I'll make an application under the RTI and get it and produce it.
I will procure it, my lords.
Pardon?
I will procure it, my lords, from the
See,
officials.
that need to be seen. Is it
Please,
a case of
please.
resignation saying that I got appointment, I want to resign, I want to go? And is it your
That's,
case of the IB also saying that, look here, you have resigned, we are allowing you, accepting your resignation, you are allowed to go? If that be so, possibly you'll have a difficulty.
My lord, in the earlier round, they filed their reply and they admitted that, my lord, I am entitled.
No, my lords, there is,
Where is that? Show us.
Page 93, my lord.
lords, then we reverted back, my lords. Initially, we were under the impression that he is entitled to pension. But later, my lords may kindly say,
ITI is not a pensionable.
ITI is not pensionable, please, my lords.
Which paragraph?
Also,
Which paragraph?
My lord, page 93, my lord, top.
Yes.
They also are eligible retirement benefit as admissible under the orders issued from time to time according to their date of permanent absorption.
That's right. Now pause for a moment. It
Please.
says permanent absorption, which is not your case.
My lord, permanent absorption is rule 37 says if
That's no applicable. Let's be clear. We are clear. It's not applicable.
my lord,
That's in the eventuality, you know, when public sectors were like BSNL, MTNL, those were formed, those people who were under the Ministry of Telecommunications were on deep depression when they got absorbed. That's benefit is under 37, but not in your case.
my lord, then rule 26(7) comes to my,
That's, see, technically, strictly speaking, 7 may not come. But if you convince us, possibly we can invoke the principle or the spirit lying under that provision to give you benefit. We are expressing so.
please, my lord.
But the fact remains, was it a technical resignation or not? That you have to convince us. It appears, we don't know, subject to you saying that you may have applied through proper channel. After you got your employment in the ITI, they may have, if they have technically said that we are accepting your technical resignation to go and join ITI, then possibly you may be right. That 10 years need to be protected, 10 years of service. But otherwise, if it is a simple case of resignation you have left, then it will be difficult.
My lord, I'll make an application under the RTI and get it. Otherwise, your lordship may direct my lord.
I will procure, my lords, I will procure, but I have one
The-
submission.
We have heard the counsel for the parties. The counsel for the respondent shall produce before the court the manner in which the petitioner was relieved from the service of IB on the petitioner securing an employment in ITI. Okay? This- All related documents shall also be produced.
Please. My lords, I have one submission. My lords, under section 37, it is mandatory that he should be absorbed in any other government
Have expressed
organization.
ourselves, ma'am.
Even if he was relieved, my lords, as per what this honorable court says, it technically, my lords, it is a resignation,
But there are,
all standards.
now you have seen 37, you have seen 26(7).
Yes, my lords, I heard him read it.
Just show us the 26(7). Do you have FRSR?
No, that's I don't.
26(7) says, just show it to her. A resignation submitted for the purpose of 37 shall not entail forfeiture of past service. That means I am resigning, I have been absorbed. 37 is absorption,
Please.
I am absorbed. I want to technically resign so that I can take the employment there.
No, but he has not placed any documents to say that he is
Why?
absorbed.
That is what we are, why we are asking all these documents. We
Please.
want to show, is it a case of technical resignation? Suppose for a moment it is a case of technical resignation. See the effect prejudice that is being caused to him. His 10 years and above service is being sought to be washed out. Can that be done? Whatever it's worth. 10 years he has worked, whatever it's worth, we will see. Next.
Is the date fixed? 9. Grateful. Serial number 30.
Yes. Yes. Yes, Mr. Joyce, tell us now.
On the last occasion, it had been requested and your lordships have permitted. the
Can you use that mic?
Pardon?
Can hear you louder.
I've also become hard of hearing. Sorry. That on the last occasion, I had made a request, which your lordships have been pleased to record and grant, that translated copies of the documents which I pointed on last occasion be placed, and they have been placed with a memo. May make a difference so that I can continue the arguments.
You can give it.
A number 2 of 2025.
IA number 2 of 2024.
Is it here?
IA number 2, filed on 31/7. Each document in the regional language has been filed along with a translated copy of each of them. Before I read now, the point that I am stressing is that the contention of the writ petitioners, that's the particularly the petitioner in the first appeal, that he was qualified and was an employee of the university. I'm emphasizing on that definite article, the university is that university, namely the first respondent university, was totally false. It was not correct. He was not an employee of any university, let alone the first respondent university. Therefore, for substantiating that, I quickly take your lordship to page number 7, the translated copy of the first document. This is dated 26 May 2021. I will read. Provisional appointment of research assistant. Recommendation letter dated so and so by the director Kuampu Kannada Adhyayana Samsthe Mamsa Gangotri. Order. As per the approval of the Honorable Vice Chancellor, Gangadharappa BO has been appointed against the post of research assistant lying vacant at the Kuampu Kannada Adhyayana Samsthe, Mansa Gangotri, Mysore, under the special project of the Government of Karnataka, also to discharge duty related to encyclopedia with a consolidated monthly salary of ₹9,000 for a period of 6 months with effect from 26/5/2011 or until further orders, whichever of the two happens first. He has to report for duty so and so. Then I skip over. Next one. The said employee is not eligible to avail any leave except general holidays. Also, he has to execute an undertaking as found below. The undertaking is here. I am aware that my appointment as per the order number so and so of the university is just provisional, temporary, and now I'm also aware that at any given time, my service may be cancelled without any prior notice. Accordingly, I have accepted the above terms. Expenditure of salary related to appointment may be borne under the head of account reserved for the implementation of the special project of the Government of Karnataka, also work of encyclopedia. Normally, he was not being paid by the university. He was not an employee of the university. That is clarified in the next document. The Kannada version is at page 10. I will skip over and go to the 11th page. It is English translation of it. It has been ordered, the second paragraph, that instead of making payment of his salary under the expenditure of the special project of the Government of Karnataka, he is ordered to discharge duty at the Manuscript Department as research assistant instead of making payment from the grant reserved for encyclopedia works, also amended to bear the expenditure under the general revenue account head of salary for the year 2011-2000. So there again, it is clarified that he was not being paid by the university. May I request your lordship's kind attention to the page number 14, Mother. 13 I skip over. My Lord Justice Ray would be able to read the Kannada version, but let me, Mother, go to page number 14 now. Here, another appointment order is issued. This also makes it very clear that he was not born on the university employment. So, as per the approval of the so and so, she has been appointed as a research assistant, so and so, in the institute's pay scale of ₹20,030, reducing ₹10 to the minimum basic pay, that is so and so. That is a fixed salary. So, this way, on a very occasion, and periodically after 6 months or 1 month or he was being, and he was not employed in the university. Now, my Lord, I, with your lordship's kind permission, go to the observation made by the learned single judge who has rejected the argument in so far as, kindly go to page number 29, my Lord. This is not an argument of me as a private respondent and a beneficiary of the under the appointment order issued, but is by the university, which is the selecting and appointing authority. May I request your lordship pay 29, para 21.
Yes.
With your lordship's leave, I read.
Yes.
The argument of the university that it was entitled to consider even those candidates who are working in an aided institution cannot be accepted, since, as stated above, the exemption clause would always have to be construed strictly, and an exemption clause cannot be enlarged to the convenience of a particular individual. The statute specifically provides for enhanced age limit only to persons who were under the direct employment of a university. which he was not. Or a government or a local authority, and this benefit cannot be utilized.
Where were you working?
But
Where were you working?
yes, I am saying that he was
That
not.
we have got it.
Then
He was not a regular employee of the university.
correct.
Hence not entitled to the benefit.
Now kindly go to page 31, that is the answer. I only read one, it will lead to your lordship to the next submission I am making. Para 26. It is therefore clear that Gangadharappa will have to be considered as an employee of the university and not of that of an aided institution. He was not working for any aided institution either. He was not working for the university. The university, Mother, I refer to the rule and make an interpretation of it.
He may be working for the university, but not as a regular employee of the university.
He was an outsourced employee, Mother, temporarily engaged for encyclopedia work on a consolidated salary, though was revised and enhanced. It was again an enhanced salary. He was not entitled to any other allowance. And he was the subject to the undertaking given that he could be discharged anytime. Now, Mother, kindly permit me to read para 26. Mother. Here is the fallacy in the reasoning of the learned single judge. It is therefore clear that Gangadharappa will have to be considered as an employee of the university and not that of an aided institution. This argument, therefore, that Gangadharappa was not entitled to challenge the recruitment cannot be accepted because his locus standi was also contested by the university. As a consequence, reliance placed upon the decision of the Honorable Supreme Court rendered in the case of R.K. Jain, that is 1993 for SCC 119, to the effect that only an aggrieved person in service jurisprudence can canvass legality of the correctness of an action would not lead to benefit. So, your lordships, Supreme Court has time and again laid down that whether there can be no public interest, pro bono publico, in service jurisprudence. The RKG is one of the judgments. So
Right.
now, I respectfully submit, while saying that you are not entitled, holding the petitioner entitled is wrong. And I have pointed out from this. This is the reason why I first read the documents to show that he was not employed in the university. Now, Mother, next argument of mine would be, as regards the rule, Mother, with your lordship's permission, page 26, Mother, para 15. Now I'm on a different argument, namely that under the regulation on which he relied, because the petitioner himself was overage, he was 39 years, 35. Therefore, what was applicable to us would be applicable to him also. So much so, he could also be appointed subject to the condition that he satisfied the requirement of this rule and that he was sought exemption and has been granted exemption. Now, kindly see, Mother, Rule 9, may I read that? Rule 9, subclass 3 of the statutes governing the cadre and recruitment rules of the employees of the Karnataka Sanskrit University, however, grants an exemption to the said limit, and the same reads as follows. Notwithstanding anything contained in Sub-Rule 1, the maximum age limit for direct recruitment shall be deemed to be enhanced in the following to the extent mentioned below. Yes, in the case of a candidate who is or was holding a post under the university, I am laying emphasis and epithet on the word the university. The university is the Sanskrit University, that is, and not any university or government or local bodies. His case is not that he was a government servant. His case is not that he was under any local authority. He was working for the university. The university is Mysore. Even assuming for a moment that he was working for the Mysore University, even then he was not eligible for relaxation, which leads to a logical conclusion that he did not have a locus standi to maintain the position. This is the submission I'm making. So he was not working. No matter what is meant by university, your lordships will kindly go to page number 55 there. I have produced the entire enactment, that is the Karnataka State Sanskrit University Act, Act number 13 of 2010, under which this university has been established. My lords, you kindly see section 2, yellow mother. I mother.
That's right.
University means,
Yes.
I read. University means the Karnataka Sanskrit University established under section 3. Read with this, if you read the rule, he must have been in the university. Then I had no argument against this, because since he did not work for any aided institution, at least we work for aided institutions. I come to the position of the institution little later, mother, how our services ought to be counted, we are entitled to education. Now, mother, without an analysis of the entire aspect, the learned judge jumps to the conclusion that they were eligible to apply, they had locus standi, and the university's argument was not correct. Our argument is rejected. Now, kindly know, say, mother, page 30. Page 30, para 24. I don't hold your lordship for a longer time on this, just only to make a reference that he produces the same documents which have now produced, obtaining them under the Right to Information Act, posterior to the filing of the appeal. It was because we did not have it, it had not been supplied the copy. When they were filed with a memo, the learned judge takes the documents on record, and also allows the writ petition based on this argument. Learned counsel appearing for Gangadharappa has filed a memo dated 10/10/2023. Along with it, she has also produced an order dated 15/6/2011, by which she was produced service certificate dated 5/7/23, issued by the Kuvempu Karnataka Dhyana Samstha Mansa Gangotri, which is a department of the University of Mysore. And in this, it is stated that the petitioner was appointed as a research assistant on so-and-so basis, and he had been working from home. This is wrong. Had the documents and the contents of the documents, as your lordships have been now pleased to peruse, had been carefully considered, the submission on the other side that the petitioner was serving in the university as an employee of the university was not correct. It had no foundation at all. So much so, if he had no locus standi to challenge, at his instance, it could not be done. It's my first submission. Now, the second submission is one on equity. Now, my lord, afterwards, now at page number 32, what the learned single judge says is, as a consequence of holding, the petitioner entitled or eligible to apply and challenge the appointments made, that too, mother, having been quashed after 12 years. The letter says that you are not entitled. Consequence of the appointment of Pagoj as deputy registrar and Shivamurthy as a section officer cannot be sustained in the same or quashed. Here, mother, I, for a moment, digress from one aspect. Shivamurthy is the appellant in 1591. There are two appeals arising from the same order. Shivamurthy was appointed initially as a section officer, and over the years, on the basis of his eligibility and also service, he has been promoted, and he is now serving as which capacity? As no called illegal. He is now murdered. Assistant registrar. Pagoji is deputy registrar. He is assistant, and during the apprentice, as far below in the year 1980, Supreme Court said it in Chadda's case that if during the subsistence of his employment, if a person is promoted in the illegality, even if there was any, in the initial appointment disappears. So such being position, he has,
And as section officer, now he is assistant registrar.
he is now in the promoted grade only. He is working as assistant registrar. And now, mother, after
For the other case,
the other case, mother, Shaileshri was
deputy registrar.
as far as Shaileshri is concerned, the observations, the learned single judge is found only in page number one paragraph at page number 31. I must have,
No,
in fact, I
here.
should have brought your lordship's notice. I'm sorry. Page number 31, para 27. This is the only in the case of Srimati Shilpasri also, respond number 4, Shivamurthy was not eligible to apply since he was aged 42 years. That I may for a moment say that Shaileshri was well within the age limit of 35.
See, the challenge is only with regard to Shivamurthy.
Yes, no, on Shivamurthy, not Bhagavaji, she had no locus standi because she was not an aspirant or an applicant for the post of deputy registrar.
Not in the case of Pagoji,
No.
Prakash Pagoji.
I'm grateful to you.
There is no challenge.
No, there are not. But since both the petitions have been combined and decided, this is the only observation. It is his contention that he was working for an aided institution, therefore he would get benefit of a enhanced age. As already held above, an employee of an aided institution cannot equate his employment to that of an employment under the government, and therefore the appointment of Shivamurthy cannot also be sustained, is what he said. So only ground on which the appointments held have been set aside, the two after 11 years, taking with great respect and without meaning any disrespect to the learned judge, a total volte-face in his order passed in the present case from the order that was passed just 3 days ago, which I point out as the first argument in the Manjunath's case. The learned judge says no, because they have served for 11 long years, equity requires that they should not be disturbed. In my case, though we have served for over 12 years, this has been set aside with a great respect, is not correct. Now, Mother, if you are also kindly permit me to make a reference to some of the rulings on which Mother I want to place reliance. But the rulings on which I relay are for the purpose of persuading your lordships to the view that long after persons have served on any ground, they cannot be set aside. Equities prevail is what the Supreme Court has said. I'm quoting several judgments. One of the judgments is from our High Court. That is, kindly go to page number 1. This is a case in which, in fact, I had appeared. That is a different case. This is a case where the narration, the facts not is in 2 minutes. This honorable court on the administrative side made appointments of large number of persons.
Yes.
That was challenged before a division bench of this honorable court, which held that the appointments were bad. That was the matter which culminated in the present order. Meantime, what happened was the special leave petitions, in fact, I had also appeared, that is, were summarily rejected by the bench by one word, as your lordships know, heard dismissed. Then on a review petition filed, this reported judgment has been made holding that the dismissal of the SLP was wrong. Now I do not try to, your lordship is going to page number 4, para 3. I have marked the portions so that I can conserve your lordship's time and do not. On July 17, 1990, notice was issued on the review petitions, and upon service, they were admitted with the following observations. The review petitions are admitted. The orders of this court and the High Court are kept in abeyance. Counsel for the High Court to state whether the present petitioners could be appointed in the suitable posts and whether the affected employees in both the High Court and also in the subordinate courts could be allowed to continue in service purely on compassionate and humanitarian consideration, since uprooting them at this stage will bring them untold miseries and to their families. Most of these persons are overage and they are not eligible to get exemption under Rule 63B. Some of them have already been promoted. That is the position in the case of the second appellant here. Some have acquired high qualification. All of them have gained experience for more than 10 years. These facts were brought to our attention when we disposed of the special, were not brought. In fact, that was our failure. This is a human problem and it requires a very sympathetic consideration. Counsel for the High Court will assist this court how best to tackle the problem. Now, my lord, kindly go to paragraph 12, my lord. Paragraph 12 at page number 7. Other things are not necessary. My lord, here, my lord, the observations contained in paragraphs 5 to 11 hold that the division bench of this honorable court, which my lord held that selections and appointments were bad. Supreme Court also affirms that. Then afterwards, having held so, even though all the appointments were not tenable and the Supreme Court passes this order, para 12 at page 7. Having reached the conclusion about the invalidity of the impugned appointments made by the Chief Justice, we cannot, however, refuse to recognize the consequence that involves on uprooting the opponents. Mr. Gopala Subramaniam, counsel for the appellants, while highlighting the human problems involved in the case, pleaded for a sympathetic approach and made an impassioned appeal for allowing the appellants to continue in their respective posts. He has also referred to us several decisions of this court where equitable directions were issued in the interest of justice, even though the selection and appointments of the candidates were held to be illegal and unsupportable. Even as on the date of this verdict, Miller, there were already precedents to the effect that equitable consideration would be. Now, next para. There is good sense in the plea put forward by the appellant. The human problem stands at the outset in these cases, and it is that problem that motivated us in allowing the review petitions. It may be recalled that the appellants are in service for the past 10 years, not here for 12 years. They are either graduates or double graduates or postgraduates as against the minimum qualifications of SSLC required for second division clerks, in which cadre they were originally recruited. Some of them seem to have earned higher qualification by hard work during their service. Some of them in the north.
We have understood this proposition. Which is the next year.
Then I skip over then because some rulings, some of the rulings have been referred to.
Just refer to it. We will note it down.
Only to para 16.
Which judgment?
Para. Though at the beginning of page number 9, second sentence may be important because
we have noted 3, 12, 13 and 16.
In the 9 also. Here, that was a case of overage employee. That your lordship sees at in second sentence on page number 9. The principal was overage for appointment, but she was given age relaxation. So, nonetheless, the precedents apart, the circumstances of this case justify a humane approach, and indeed, the appellant seemed to deserve justice ruled by mercy. We take note of the fact that the writ petitions would also be entitled to the High Court as stated with learned advocates of the state. In the result, we allow these appeals and direct that these appellants should be treated to be regularly appointed with all the benefits of past service. The judgment of this court is accordingly modified. High Court is modified. This order would govern all those whose appointments have been quashed by the High Court. Therefore, even after mother appointments had been set aside, the Supreme Court passes this order. Then mother, in the next citation, may I proceed now? 1990, next citation is at page number 11, mother. That is 1990, volume 3, SCC, page 48. Then mother, here again, the relevant portion may be seen the para 3 at page 12.
Yes,
Para 3.
you give us the
At-
para numbers.
I have given the para number 3
Uh,
at page 12
and
and para 7. Also, last para is 9, 9,
7.
9, 9. 3, 9, and 7 mother, are the relevant paragraphs where mother identical considerations have weighed.
Okay.
Then mother, let us go to the next judgment, mother, which is page number 14. It is 1990, volume 2, SCC, page 189.
Yes.
There again, mother, without mother daylighting much on that, I only go to page number 191 in printed page, which is ink page 16. A few
Which
lines,
para is
maybe
that?
after 10, 12 lines. Many a time, strict application of service rules.
Which paragraph?
Well, I'm reading the head note itself. Head note, it is para 6 to 10. Therefore, the findings are followed. Many a time, strict application of service rules create a situation where a particular individual or a set of individuals may suffer undue hardship. And further, there may be a situation where the requisite qualified persons may not be available for appointment. In such a situation, government has power to relax requirement rules, state government, etc. Then the next para, that is paragraph 12. Since the appellants had already completed 8 years service in class 2 service during the pendency of the writ petition, their appointment, if irregular, stood regularized on the day. So the Supreme Court itself says irregular appointments stood regularized. On the date they completed 8 years of their service, and thereafter their promotions could not be satisfied. So I don't skip over mother only. I will point out paragraph. Your lordship may kindly notice para 5, para 8, para 11, entire para, and 12. These are the paragraphs in this case. Only to save your lordship. Then, my lord, another case, of course, I was also one of the.
You give us the para
Yes,
numbers, that's enough.
page number 24, mother. That
What
is
are the para numbers
2008,
in-
volume 2, SCC, Timmaya's case. Here again, challenge was on the ground that there is entire selection was mala fide. And the Supreme Court did not accept the argument, upheld the submission. I only refer to the pertinent paragraphs, that is page number, ink page 31, I'm sorry, 35, para 19, para 22 at 38,
Yes.
para 30 at page number 40.
Okay.
And my lord, after that, paragraph 32, 33, because previous judgments, there are the precedents on this issue, have been referred to, and whether they say that they uphold the appointments and they reject our argument. In fact, I'm making because I was one of the lawyers for the special petition. I got defeated there. Now, mother, I take your lordship to another ruling which is found at page number 55, mother. 55, that is 2001, volume 3, SCC, page 110. I only point out at page 62 the relevant portion. No, skip over all the other aspects. Here, my lord, their lordships follow the celebrated ruling of the Supreme Court in Govindara versus Mysore University. AIR 65, Supreme Court, page 91. It's a constitution bench of Justice Gajendra Gudkar, where the lordships said the selections and appointments made by expert bodies, particularly for academic posts, should not be interfered with. The courts are not sitting in appeal over the decisions and judgments of the expert bodies is what, therefore, I will only 4 sentences, 4 lines, Mother, at page 62. When expert qualification, I'm sorry, expert when expert qualification is a typing mistake. Ordinarily, court will not interfere with such matters. When University of Mysore was a CD Govinda Rao, it was observed that normally it is wise and safe for the courts to leave the decision of academic matters to expert who are more familiar with the problems they face than the courts generally can be. So, contrary to this Mother principle well laid down by the Supreme Court, this has been done. Then now Mother, the next citation is at page number 63. That is University of Mysore. Your Lordship sees the head note D at page 64, so that I need not read the entire judgment.
Yes, we have seen that.
I will. At 65, I have marked the portion, and my lords will also see page number 69, para 13, Mother. With that ruling, Mother, is. Then, Mother, I take your Lordship to the judgment of the Supreme Court in 2011, that is University Oxford Press case. It is found at page number 70, each page is 72. I refer to your Lordship only the relevant observations found at page 89, para 33, because reading all these judgments will take 3 days. I skip over. I want to conserve your Lordship's public time. Page 33, para 33 at 34 also. Then it is also a case of definition of university, what is meant to university. Then, my Lord, we have, with your Lordship's kind permission, I refer to a judgment of His Lordship Justice Venkatramaya as His Lordship then was, which is at page 44. The citation begins at page 103. I'm sorry, 103. On 1980, volume 4 SCC 653. The relevant portion on which I place reliance is found at page number 44, ink page 44, para 15 in particular, and then para 21, and the last few sentences on page 118. It is a question. Their Lordship say, His Lord, we however make it clear that the view taken by us in the present case does not necessarily lead to a conclusion that a very employee of a local body who is not a member is so and so on the facts of that case. No, that there is another judgment from which arose from our division bench of our High Court. That is at page 119. D.S. Parvuswamy versus so and so KSRTC, 1991, supplement to SCC, page 443. Here again, my lords will kindly note, page 121, para 4, last 10 lines, which are relevant, and then para 6. With that, I conclude this admission on that. On para 6 here.
Which para?
Paragraphs, I'm sorry, I'm adding. Para 4 and 6. Last 10 lines on para 4 and para 6. Then, at page Om Prakash Sharma's case, only a few lines. We however hold that not necessary. Then the last judgment, it is a penultimate one, not the penultimate one. That is here, Mother. This is again a case of employee. It's really, I'm sorry. By force of habit, we may use our regional language. Paragraph 4 at page 125 and the entire para at page 5. I'm sorry, para 5, 126. There the relevant observation is Suffice it to say, that is last 6 lines from page number paragraph 5. Suffice it to say that all the selected candidates who are in employment except one possess necessary qualification, and in this regard, regard, that one, it cannot be disputed that he possesses equivalent qualification. Thus, the dispute narrows down to one aspect, that his selected candidates may not possess necessary experience, which is now required to be examined. Then the last paragraph 6, their lordships say, middle of para 6, we have extended equitable consideration to such as selected candidates who have worked in the port for a long period, but the contesting respondents do not come in this class. The effect of our conclusion is that appointments made long back pursuant to a selection need not be disturbed. Such a view can be derived from several decisions of this court, including the decisions in the Ram Swarup, so and so, etc. H.C. Puttaswamy, the first citation which I gave, and other holding so save the appointment. But seeking your lordship's pardon, and I only make a little more reference to the last judgment, which is not in this, but is the more important. That is, citation is 2010, volume 8, 372, which is ink page 127.
Which page?
127. Here, mother, I only make a reference to paragraphs 13, 19, 20, 21, 22, and mother, till the end, mother, there are, because this only.
Which is the last paragraph?
I quickly say, mother, why I make a detailed reference is, here your lordship sees in page number 20, I'm sorry, para 20, last 4 lines. The expert committee had in fact scrutinized the merits and demerits of each candidate, including the qualification equivalent to publisher work, and its recommendations were sent to university for appointment. Para 21. It is settled legal position that the courts have to show deference and consideration to the recommendation of an expert committee consisting of distinguished experts in the field. In the instant case, the experts had evaluated the qualification, experience, and published work of the appellant, and thereafter recommendations for the appointments were made. The division bench of the High Court ought not to have sat as an appellate court on the recommendations made by the country leading experts in the field of so and so. A similar controversy arose about 45 years ago in regard to so and so. That is Govindarao's case, which I have already made a reference. I don't repeat that now. Then there are totally about 9 rulings of the Supreme Court, which have taken an identical view that the decision taken by expert bodies, particularly academicians of far eminence, they should not be interfered with, and this is submission. Now, here is a case where the selections were made by a committee of board of appointments consisting of experts. But your lordship, it has been placed on record. Then, my lord, it was placed before the syndicate university, which is the highest economic body of the university. Syndicate approves it. Thereafter, the appointment orders have been issued. And though the challenge was not belated, I cannot say that the challenge made was belated, though it was a few months from the date of appointment that it has been challenged. I do not make much of it. But challenge, having though had been made immediately or a few months later, has been quashed, after 12 years, and taking totally a different view than what the very learned judge took in Vanjanath's case, on which I do not want to bear repetition. I'm grateful to the court for this. Any clarification required from my side, I will be too glad. Last aspect, if I'm permitted, on the last occasion, your lordships asked me as to how you would equate your service in the Sanskrit colleges rendered. For that matter, a document is placed in the, it is at page number 272, paper book. Page number, I will be failing if I am. Page 272 is the Kannada version. English version is found at page number 275. Stating the background in which this government order has been made.
Yes.
Government passes this order. With this method, though it may take 2-3 minutes, I will seek your lordship's pardon and other take your lordship's time also. Page 2. In the above read government order, 3 government Sanskrit colleges, 9 aided Sanskrit colleges, that is the colleges where we were working. 3 aided Sanskrit colleges are working in the state of Karnataka. The Sanskrit colleges and the Arabic colleges have been transferred from the limits of primary and secondary education department limits to Commissioner College Education Department of Higher Education Department along with the teaching and non-teaching staff. Kindly note this. In the background of establishment of Sanskrit University in the state, in order to conveniently run the administration of Sanskrit colleges, detailed discussion has been made in the meeting held in the chairmanship of the Principal Secretary Government on 9/6/2010, and following recommendation has been made. A separate Karnataka Sanskrit Directorate must be established, constituted in order to work under Sanskrit University. 2. The present Sanskrit colleges, this is very important for my colleges, schools and Sanskrit Mahapatashalas, that is Sanskrit, must be transferred to the newly constituted directorate in the limits of the university, along with the teaching and non-teaching staff. Sure. Then commissioner of so and so. Then that separate budget, government operative portion, the order is at page 277. In the background of aspects mentioned, explained in the proposal, the following order has been issued with bringing the Sanskrit colleges, schools and Mahapatashalas into the limits of Karnataka State University, along with the teaching and non-teaching staff working in the said college from the limits of the Higher Education Department by modifying the good. Formerly, they were in the Higher Education Department, then it has been transferred to Collegiate Education Department. Then the staff have been also. Therefore, and most important aspect is this government order has been issued after the Sanskrit University Act came into force and before the notification order for recruitment was issued. It was well before that because the notification was issued on 16/7/2012. And this is an order made in 2010 itself. University had been established and the government, the college had already virtually become part of the higher education, collegiate education department of the state. And therefore to say that our services cannot be countenanced with due respect is not correct. And therefore even on the locus standi of the petitioners, that the finding is not correct.
Thank you.
That the short question before your lordships would be the eligibility condition so far as the fixation of age in terms of Rule 9 has been incorporated in the notification. Age relaxation has been given in a restrictive manner than any other, my lord, the definition. If your lordships kindly take 26 of the paper book, I will not take much of your lordship's time. The maximum, my lords, first petitioner is 44 years, second petitioner is 42 years. Notification says it should be within 35 years as on the last date of receipt of the notification. Your lordships are aware of it, the judgment of my Lord Justice Sai 97 4 ACC, page 18, where the two judges, the matter referred. Unless and until the rule otherwise provides, the eligibility of a person shall be determined is only the last date fixed in the employment notification. And the sentence says that date alone, that is para 6. Now, my lord, here, the maximum age limit for direct shall be deemed to be enhanced in the following. In case of a candidate who is holding a post under the university or a government or local bodies, corporation, city municipal council are undertaking by the number of years, my lord, holding such post, any whichever is less. Now, this is a restrictive meaning. The employees, my lord, who are working in the aided institutions is not included under Rule 93A. This age relaxation is only restrictive in character. And the fixation of a age limit, which is a condition of eligibility to apply for recruitment. It is the policy of the employer and by means of a recruitment. Now, my lord, so far as my locus is concerned, my learned friend read that. In fact, the research assistant, I have translated, my lord, the charge sheet which has been issued, and C&R rules is also placed on record. I will take your lordships only page 51. The research assistant is a direct recruitment, a cadre post. Page 51. Research assistant grade 1, research assistant grade 2 have been appointed as per these recruitment rules, grade 2.
Where is that?
Item 85.
51.
Item 85, my lords.
Page 51
Page 51, my lords.
of the TIA.
Document number 5.
Document number 5,
Yes, my lords.
that's 54.
Page 51, item 85.
Item 85.
No, not in the main paper book. I just now, along with the translation. I'm sorry, my lords. Document number 5, page 85, entry 85. This is Institute of Kannada Studies, Manasa Gangotri. Mysore, MGM. 84 Research Assistant Grade 1, 85 Research Assistant Grade 2, 3 posts.
There is no dispute on that.
Yes. Now, let's, so far as locus is concerned, then page 8 till today, let's, I am working as a research assistant, temporary post from 2011, 12 and 12 to 14 till today. This is the position.
But are you working under that project or a scheme?
It is a cadre post. It is a cadre post.
There is no dispute on that. It's a cadre post.
It is a cadre post. Comes under Kuvempu Institute of Kannada Studies, Manasa Gangotri, Mysore.
What is being argued is, but insofar as this gentleman is concerned, he was appointed, though nomenclature is research assistant, but against a project or a scheme, that encyclopedia scheme. So in that sense, it is not a regular appointment under the university.
But this is a temporary post according to the notification.
The nature of appointment is temporary.
Temporary post. It is a cadre post. Your lordships are aware of it. cadre consisting of both temporary and permanent posts. I am working in Kuvempu University of Kannada Studies, Manasa Gangotri, Mysore. The C&R rules which I have produced is Institute of Kannada Studies, Manasa Gangotri, Mysore. So therefore, so far as my locus is concerned, there is no difficulty. That was not seriously challenged before the learned Singha judge. This is the position. Now I am working, I have been directly recruited as a research assistant and I have been working there till today is the position. Now, so far as the controversy in question is concerned, whether employees of the
Mr. Abhinav, you are appearing for whom? University. Your university? Yes. Okay.
the employees of the aided institution would not come within the purview of this age relaxation category mentioned. My next submission to your lordships is, what would be the age cutoff date or the age prescribed, which is a condition for recruitment, is the policy of the employer, which I'll readily cite the apex court judgment. So therefore, on that is a short question. Can you apply when you are working with another employer? A charge sheet has been issued that the gentleman has produced a false certificate. He has not forwarded, the university has issued a charge sheet stating that he has produced a false certificate. He has produced a 5 years false certificate. He has forwarded the application without an NOC from the employer, which is bound to do contrary to the notification. And the charge sheet is still pending and inquiry is still pending. That's a different matter. Now, the short question is,
On the same conduct.
same. That is why, Melody, along with the translation I have produced. Charge sheet is already there in the record. And this has been gone into by the learned Singha judge. He did not express opinion because the charge sheet is still pending and inquiry is pending. Whether he would retain or not, that's a different matter. But there are serious charges against him. He has produced an experience certificate stating that he has attended the Haridwar conference. On that day, he has attended in the college. That is how the charges are. He has produced a 5-year service certificate, which are going to be a fake certificate. Charge itself is fake. Now, Millets, the short question would be whether this condition precedent of 35 years can be relaxed by the courts. The answer, of course, the apex court said it is a policy decision. There can be no judicial review on this. Now, if the employer prescribes 35 years is the upper age limit, it cannot be relaxed by the courts. Now the last date of the application is over. The recruitment is over. Now there is no writ petition filed by the appellant before your lordship stating that this rule 9(3)(a) is discriminatory, therefore I need a relaxation. That effort has not been made by him. That is one. Today he can't plead before your lordships to relax the age, because if once the relaxation is made today, the apex court said, without a power of relaxation, that relaxation cannot be exercised by the court, either by the employer or by the court. If the courts on the touchstone of Article 14 relax it, then there shall be a fresh notification, because if aided institutions age is relaxed, thousands and lakhs of people are eligible as on that day. That's the criterion. Right? Objection might be. Now, my lords, therefore, as a respondent before the court, the only question before the learned single judge was 35 years age fixed by an employer under Rule 93A. You would take the benefit of it or not? The answer was, you don't come under such category. You exceeded your limit. Therefore, your appointment is illegal. Now, my lord, all the judgments which my learned friend has cited pertaining to the age relaxation so far as regularization is concerned. Age relaxation of regularization, day in and out, my lord, your lordships have granted age relaxation and also the experience certificate. Weightage has to be granted. But so far as the recruitment is concerned, age relaxation is different. The courts have no power to relax the age relaxation. Let's the
Like to interrupt, friend, but I won't.
no, I did not intervene.
I am only requesting, he need not labor on the question that the courts cannot relax. I am not asking for relaxation from the court. Therefore, I concede the legal position that courts cannot relax. Therefore, it's only for saving his time and your loss of time.
His argument is this relaxation under this regulation 9 is available to him. One, alternatively, he says, it's been 12 years now. The court should not, set aside the appointment. Those are broad submission which he is making. And three,
Blood,
in
if-
fact, he is challenging your locus to get consideration.
Yes, ma'am.
These are three broad.
Yes, my lords. Number one is ours is an adversary system, the petition is pending. Two, a person whose appointment is contrary to the mandatory rules of eligibility is a void appointment. So therefore, whatever the salary which he has earned is nothing but a bonanza for more than 10 years. So that's the position, my lord. So whether it is 10 years or 15 years, if it is not challenged, my lord, that's a different matter. Kindly take, my lords, 2020-17 SCC. I'm sorry, I'll take only 401. ಇಲ್ಲ. Paragraph 27, my lords. 2020-17 SCC, page 401.
Yes.
But I'll just read. Ramesh Chandra Agarwal has been extracted, my lords. Para 27. These judgments provide a clear answer to the challenge. The petitioner and the appellant desired that this court should roll back the date with reference to which attainment of the upper age limit of 48 years should be considered. Such an exercise is impermissible. In order to indicate the fallacy in the submission, it is significant to note that Rule 12 prescribes a minimum age of 35 years and an upper age of 45 years, 48 years for reserved candidate belong to the SC and ST. Under the rule, the age limit is prescribed with reference to the first day of January of the year following the year in which the notice inviting application is published. If the relevant date were to be rolled back, as desired by the petitioner, to an anterior point in time, it is true that some candidates who have crossed the upper age limit under Rule 12 may become eligible. But interestingly, that would affect the candidates who on the anterior date may not have attained the minimum of 35 years but would attain the age under the present rule. We are adverting this aspect only to emphasize that the validity of the rule cannot be made to depend on the cases of individual hardship which inevitably arise in applying the principle of general application. Essentially, the determination of a cutoff date lies in the realm of policy. A court, in the exercise of the power of judicial review, does not take over that function for itself. Blindly, it is for the rule-making authority to discharge that function while framing the rule. Now, my lords, there are 5 to 6 judgments only on this principle. So far as the fixation of the age as the minimum for the purpose of the eligibility for recruitment is the prerogative of the employer.
There is no dispute on that proposition.
Yes, my lords. Now, in the present case, since the appellants before your lordship did not come within the rule 9(3)(a), therefore the learned single judge literally interpreted the rule and said, you do not come within the purview of age relaxation. And see the directions blood issued by the learned single judge. The respondent university is directed to consider the applications of the petitioners along with other applicants. Appoint the most meritorious among them. The university shall consider only those candidates, including the petitioners, who are eligible, keeping in mind the decision rendered in this case relating to the nature of the employment. It is not a case where a mandamus has been issued, we should be appointed. The nature of the direction was keep the rule 9(a)(b) into the focus, then screen all the application and consider the eligible persons. Now, if your lordships, that is one aspect. Of course, my lords, the relaxation of a age in the recruitment is entirely different from regularization. Is 98(8) SCC 736 minutes. There are other 2-3 judgments where it says courts, while interpreting the rule, if relaxation is granted retrospectively, after the selection process is over, which is impermissible. If it is granted, a fresh notification is required. If the relaxation is granted, a new criteria group of people would come. So therefore, such a course of action is impermissible. Now, these are all the decisions. It is a well-settled principle.
But the relaxation has been given.
Yes.
It has been given.
Has been given.
Yes.
Now, the only thing is whether their case or your case, both cases fall within the relaxation. That's it.
Correct. Whether the employees of the aided institution, if your lordships kindly take minutes, the present application which we have filed, this first appellant before your lordship, a charge memo has been issued by the university.
Sir, that's a different argument.
Page 53.
One, relaxation can be given. If relaxation can be given, his case can be considered with this background. Can he be appointed? That's a different argument, but that's not the subject matter. Even the learned single judge did not go into it. The only thing.
No, the learned single judge did not adhere to this question.
That's right. For the reason he has been, the petitioner, the appellant has been dislodged on the first argument only.
Correct.
That
Because
means relaxation can't be given.
Because the notification says that you will have to apply through your employer along with the NOC. Now the charge sheet by the university is you have furnished a false certificate, You are not applied through your employer, and you are not forwarded your application through your employer, and no NOC is annexed. Well, these are all the charge sheets. So therefore,
Who has issued the charge sheet?
the university.
The university, after his appointment there.
After the appointment.
Okay.
That the notification condition 10, 15 has been violated. Therefore, a serious charge sheet.
Then why did they appoint him? Knowing well that it has not come through.
Suppression of facts, suppression of facts.
They should have seen it. We will put it to Mr. Abhinav.
No, that question, my lord, has not been gone into by the learning.
We are now, today its only issue is relaxation. So that's the first stage.
At the threshold, if condition precedent eligibility, if it is not satisfied by a person,
Yes,
the appointment is not irregular, it is a void appointment, illegal appointment. That's the position. And if my learned friend has pleaded, all these judgments pertain to the regularization. If relaxation is granted today, as he is working in the aided institution, all employees of the aided institution, as stated by the apex court in para 27, the eligibility would come. Many of them would have been applied as on that date. Number one. Two, you are creating a new class of eligibility now by virtue of this relaxation.
okay.
So, retrospectivity, relaxation is impermissible. If it is granted, a fresh notification is required.
So
And that-
larger concern.
Yes.
Okay.
So therefore, my lords, there are 2-3 judgments on this. I will just pass on along with the memo. And my lord, this is the crux of the matter. I am not going into the relaxation in case of regularization, what my learned friend has adverted to,
Yes.
and decision of the academic expert, no, my lords. That may not be applicable because the court is dealing with the situation whether do you satisfy the eligible condition prescribed by an employer in the rule and the notification. And the answer by the learned single judge was no, you are not eligible. That's the position. I'm grateful.
Yes, Mr. Abhinav.
The question is, my lord, whether both the candidates, my lord, were admittedly, my lord, beyond the age prescribed by the statute.
There is no dispute on
There is no dispute about that. So therefore, my lord, the only way they would get, my lord, the benefit is, my lord, the statutes, my lord, provides for age relaxation, depending on, my lord, the service rendered. Now, that has been interpreted by lord as service rendered in an aided institution as well.
Where is it interpreted?
My lord, interpreted by the board of appointment. Yes, please.
By the?
Board of appointment. My lord. There is a board of appointment. And my lord, this stems from the fact that, my lord, there is a government order which is now produced at page number 275. In the first writ appeal, my lord, please take page number 275. That is, my lord, writ appeal number 1590. Why both these things were clubbed, my lord, is both the issues, my lord, both the writ petitions involve age relaxation. But for that, my lord, it is for different posts, grounds of challenge are also slightly different, my lord. Since the interpretation of rule 9.3 is, my lord, involved, it was taken up together and a common
Which page
judgment.
you said?
My
Page?
lord, page number 275, my lord takes.
In which repeal?
In writ appeal number 1590 of 2023. That's a government order, my lord, by virtue of which, my lord, all the, please take, my lord, page 275. There were 275, my lord, in the first appeal. This is a government order, my lord, of the year 2010.
Yes.
My lord, they read a government order, my lord. Then they say 3 government Sanskrit colleges, 9 aided Sanskrit colleges, 3 unaided Sanskrit colleges. All these are, my lord, are handed over and given to the control of the newly established Sanskrit University. This is the government order, my lord, by virtue of which, my lord, it is given. So,
No, given the control means?
my lord, a new university was, my lord, established. Next year, if my lord sees, my lord, a new act was brought into force for the purposes of, my lord, establishing the Sanskrit University.
Okay.
Earlier to that, my lord, it was under the Department of, my lord, Primary Education. Subsequently, it was transferred, my lord, and this new university had to be given control of all the Sanskrit colleges, which were otherwise, my lord, before, my lord, under the control of the government.
But all these colleges gets affiliated to the university.
Affiliated and come under the control of the university.
Okay.
That is the government order. In this background, my lord, they said 9(3), when service is rendered in any university local body, that was interpreted to mean service in an aided institution as well. Because
Suppose there is an unaided institution
unaided institution, my lord,
under the university because it's affiliated to the university.
yes, my lord. What happens, my lord, when there is aid that is given is, my lord, the rules of the university will apply to that institution. Whereas in an unaided institution, my lord, they are free to have their own rules and regulations, my lord. So therefore,
They would be governed by the University Act
they would be,
to the extent applicable.
yes, my lord, to the extent, because once we give aid, my lord, everything has to, my lord. So therefore, my lord, if a candidate was working under an aided institution, my lord, this was 2010, the act came into force. 2012, these appointments have taken place. So, my lord, the number of people who are available were very limited. So therefore, my lord, the interpretation that was given was a person who has worked in an aided institution under the Sanskrit University or erstwhile under the government would get the benefit of age relaxation. Now that the learned single judge says, no, that is not available without looking into the background. That is the dispute, my lord.
Was this there before the?
No, my lord, this was not there. But it was argued saying that all the university, my lord, when the was established, all the aided, unaided institutions, everything was given under the control. He has answered that by saying, working in an aided institution does not mean working under an university. That is the interpretation.
Because the relaxation says local authority.
Yes, my lord.
It's
Relaxation says university, government, and local authority.
It's something you are bringing in the concept of, state within the meaning of Article 2.
Yes, please, my lord. Yes, please. What the learned judge says, my lord, takes note of that fact, says no doubt, yes, it may be true, saying that all aided institutions have come under the university, but working in an aided institution is not working under university. That is the, my lord, strict interpretation which the learned single judge does and says, therefore, you are not entitled. So therefore, whether the strict interpretation, my lord, is valid would be the limited question in my respectful submission. Because both of them, my lord, are claiming the benefit of age relaxation because both of them have crossed 35. And maximum age relaxation is, my lord, 10 years as per the rules. The statutes, my lord, are framed under the university rules. There is no dispute about all those things. Only dispute, my lord, is whether it can be interpreted in such a manner. Of course, in the first case, my lord, the additional argument is you had no locus to challenge because you were not even working in an aided institution. It was some sort of a scheme which was of a temporary nature. So if you don't have locus or a probable occasion to get appointed to the place where you are challenging the selection of a successful candidate, it is a futile exercise. Even if you were to succeed and you don't have the basic qualification, question of annulling the appointment or selection would not arise. That is, of course, what my learned friend has argued. But for that, my lord, this is the only criteria or basis. There is a board of appointment. Board of appointment has said, Lord, and it is universally applied. It is not, my lord, that we have done a pick and choose method. And my lord,
but the only thing what has been argued is,
yes, my lord,
you still retain that relaxation to mean university, local bodies.
even to this day, my lord, even to this day, we are applying that as aided institutions. Because what happens, my lord, is Sanskrit, my lord, I must have a person, my lord, who has understanding of Sanskrit. My lord, unlike other fields where the, my lord, area is wide for appointment, for Sanskrit, my lord, it comes down very narrowly. So therefore, my lord, university, if I see, my lord, except
Not many people.
not many people are there. And my lord, ultimately, I have to select a person, my lord, who will discharge his duties, my lord, as required by the law. So therefore, my lord, this interpretation was brought about. It cannot be said that it is arbitrary or without any meaning. Because, my lord, aided institution person is working, discharging. Only thing is, my lord, he may not be an appointee under the university or, strictly speaking, a government employee. As the learned single judge has said. Learned single judge says, look here, he is not an employee of the university. He is not appointed as against a post of the university. The government is not the employer, therefore you can't give this relaxation.
But you did not challenge the judgment.
I did not challenge the judgment. I have not challenged the judgment. I have supported our selection, my lord, and
What do you say about the other, his locus, the locus of the respondent who was the petitioner there?
Lord, the locus, my lord, is, we found that, my lord, he had no locus. For the simple reason, my lord, he was working in a scheme. And it was a scheme which was only temporary. Of course, it was a sanctioned post. It was a cadre post. But
As a research assistant, there is a cadre post in the university,
and this.
not under the scheme.
Yes, my lord. Under the scheme, my lord, he was working temporarily. The moment the scheme is over, my lord, it goes. It is different from working in an aided institution. Aided institution, my lord, there is some element of permanency, which may not be so in the, even otherwise, my lord, if merit is seen, my lord, the entire evaluation is placed before the court. If merit is seen, my lord, in both the cases, the appointees have been, my lord, more meritorious than the persons who are challenging it. Keeping this challenge to, my lord, the relaxation that is given. My lord, merit, when it comes to merit, my lord, both of them are ahead in merit. It is not, my lord, the rules were tweaked or, my lord, distorted only to select somebody who has got lesser, my lord, merit.
But did you get application from other aided institution persons working in?
Yes, my lord, yes, my lord, yes.
Because what is the argument is, this relaxation as it exists,
Yes, my lord.
it doesn't say that even a person working in a aided institution can also apply.
True, my lord, true,
So
my lord.
those people may not have applied.
True, my lord,
If
true, my lord.
those people may not have applied, surely something, the benefit inured.
True, my lord, true, my lord. The statute does not say so. The notification of employment does not say so. It is, my lord, given as an age relaxation because 9(3), my lord, contains it. So therefore, my lord, if any person wanted that benefit of that, my lord, he could have definitely, my lord, made a claim as, my lord. Because both of them are claiming age relaxation on the ground that they are working in an aided institution or under an university.
University in.
Yes, my lord. Even whether, my lord, he would be, again, my lord, if the learned single judge's criteria is applied, there must be an appointment order. He must be an employee of the university or the government. He will not, my lord, satisfy that. So therefore, his challenge goes, and if that goes, my lord, his criteria to challenge also goes, or his eligibility to challenge that also goes.
But did he apply for both the posts like deputy?
No, my lord, no, my lord. He applied only for, my lord, deputy registrar.
So insofar as the challenge for section officer is concerned, he did not apply.
No, he did not.
Then there would be an issue of locus.
No, my lord.
Second,
No, it is
there are two writ petitions.
entirely different, my lord.
Second petitioner, the challenge was that the selected candidate did not acquire a degree qualification, therefore is an ineligible. That's it.
It was
Two
clubbed
writ
only-
petitions
it was-
were clubbed.
It was clubbed only because, my lord, the learned single judge felt that this relaxation cannot be given. And in both the cases, the university had relaxed the maximum age on this rule. So for that purpose, my lord, it was clubbed. Otherwise, my lord, it is not a case where they had applied for two
So
posts.
your case, your interpretation, your clause is that even person working in an aided institution shall meet the requirement.
Yes, ma'am. Having regard to the government order, my lord, which is an undisputed fact, government has handed over control of all these aided institutions. The judge has been, my lord, in my respectful submission, my lord, too strict by saying that you are not an employee. My lord, even under a local body, my lord, which is prescribed, he does not become an employee of the government. My lord, even if it is a post. So therefore, my lord, that seems to be the criteria, saying, look here, you are not under any sanctioned post. Please have a look at that part of the
But
order.
the
my lord.
government, it also says government.
Yes, my lord, it also says government, but my lord, when it says local body, what the learned single judge, my lord, seems to interpret is,
No, local body will not, like the, the municipal corporation.
yes, my lord, so,
Under the act.
yes, my lord, here, my lord, relaxation is given to university as well as persons working in local bodies.
That's right.
So therefore, my lord, the strict interpretation that, look here, you are not an employee under the government, sanctioned post, which seems to be the reasoning given by the learned judge, my lord, may not apply having regard to the relaxation criteria fixed, which also applies to persons working under local bodies.
But going by this,
Yes, please, my lord.
let's assume a college which is under the government.
Yes, my lord.
There are Sanskrit colleges under the government.
Yes, my lord.
That is also missing here. You read
Yes, my lord.
under the university.
True, my lord.
University is, the college is affiliated to the university. Here, what is university meant means an employee who is appointed by the university, unlike the college.
Yes, my lord. Therefore, my lord, please have a look at how it reads. My lord kindly takes that, my lord. My lords might have seen it, page number 247 in the first petition.
Yes.
That is the rule, my lord. Notwithstanding anything contained in sub-rule 1, maximum age limit for direct recruitment shall be deemed to have been enhanced in the following to the extent mentioned, namely, in the case of a candidate who is or was working or was holding a post under the university or government or local bodies, corporations, city municipal councils or undertakings of government by the number of years he, she is or was working under such post, the number of years holding such post or 10 years, whichever is less, correspondingly age will be relaxed. So therefore, my lords are completely right, my lord. That criteria is also not there. My lord, we should, my lord, subsume all colleges, my lord, which are drawing aid from the university, my lord, will virtually, my lord, work as per the dictates of the university. That is the logic, my lord, which is applied. It has come up for the first time for interpretation. So there is no precedent on this. And up till now, my lord, the university has been following this for all appointments. Of course, university, my lord, will have a greater role, my lord, if it is said that, my lord, these aided institutions don't come. Probably, my lord, lot of appointments.
Even as of today also this interpretation.
Yes, my lord, because statute, my lord, this is a part of the statute. Statute is worded like that. And therefore, my lord, it could have been better worded, but what we have is what we have, my lord. And
Okay. That's all.
No, only one. Let the stand of the university, page 275. Only one submission, my lords. The tenor of 275 page would be, when the Sanskrit university came to be established, all Sanskrit colleges brought under the Directorate of Sanskrit Directorate. It doesn't deal with the age relaxation. That is in 2010, page 275. If your lordships kindly see the government order dated 15/10/2010 and the notification read in 2012. So therefore, I only submit your lordship, 275 is not an instrument of a GO to contend by the university that the GO is to be interpreted or to be accepted as the age relaxation in a recruitment. If the notification, my lord, as follows, Rule 9(3)(a), because the notification doesn't contain the GO. Notification does only in consonance with the statute. The university should be guided by the rule framed by under the University Act. So therefore, I only submit that the argument of the university, my lord, is contrary, giving up the rule, mandate of the rule, by relying on 15/10/2010 GO, where it establishes the Directorate of Sanskrit Department, where colleges comes under this Directorate of Sanskrit. It is not a GO to relax.
Let's ask him. Yes, Mr. Abhinav, where is the relaxation here?
pardon me, Lord. There is no relaxation, Lord. All that I said was, Lord, aided institutions are brought within the control of the university. That seems to be the reason for considering persons who have worked in aided institutions as persons who are, that is the, my lord. I am not saying, my lord, that this notification prescribes, my lord, relaxation.
Doesn't prescribe.
It doesn't prescribe. What it says is, my lord, all the aided institutions are, my lord, given to the control of the university. And therefore, my lord, for us to consider a person who having worked in an aided institution, this seems to be the reason. That's all, my lord.
What you are saying is it's as good as a university. They are
Yes,
working in
because of
university.
this, because of this, because of that is. It does not prescribe age
It is only
relaxation.
for the purpose of affiliation, like Mysore University and the Bellary University, Dharwad University, Gulbarga, my lords, Mangalore University, Bangalore University. So therefore, if once the university is established and a directorate would be established and a separate statute would be framed, and the university has issued a notification based on the statute. So therefore, they can't go back beyond that. Then, my lord, so far as my status is concerned, if your lordship kindly sees the cadre, my lord, the cadre is Institute of Kannada Studies of Manasa Gangotri, Mysore. Now the appointment is, my lord, is working as a Kuvempu University as a research assistant post from so and so. So there, but it is a temporary post. My lord, so far as the research assistant is concerned, not only in Sanskrit University, it is a general phenomena in almost all universities, whether it is a state university, central funded university, they are all, my lord, doing the research work under the various schemes. So therefore, what is criteria is whether a sanctioned post research assistant grade 2 and he has been directly appointed and is still working. Therefore, my lord, he has got a locus. That's the position.
Thank you. Reserve.
Age
My lord,
relaxation.
morning only 3 to 4.
Yeah, just give the
Age cannot be relaxed retrospectively. And if it, yes, I am sorry, my
Why
lord.
do you say retrospectively?
Suppose, my lord, if an argument of both sides are accepted, then your lordship would be relaxing as on the last date of receipt of the application. That is not permitted. If it is, my lord, only in touchstone of Article 14, but as a respondent, he cannot get the relief of the petitioner. So therefore, a respondent, my lord, he cannot claim the relief of the petitioner. He should have come before this court the moment list is filed before this court stating that along with the other statutory authorities, you have extended the benefit. Therefore, you also extend to us. That relief is not there. So therefore, that prayer cannot be considered because as a respondent, they cannot claim the benefit, which amounts to adding a new criteria under Rule 93A.
That's right.
That's position.
New criteria of aided college.
Yes, my lord. Not only aided, my lord, if aided, my lords,
No, surely in the facts it is aided, that's your contention.
yes, yes, my lord.
Both of, my lord, page number 102.
Whether it is aided or unaided, my lord, if a person is working in a private institution, whether it is aided or unaided, my lords, the thousands of,
It's not a university.
yes, it's not a university.
So page number 102.
And when the university has not amended its statute, Rule 3B, my learned friend should not contend stating that the government order of establishment of the directorate, which amounts to relaxing the age relaxation, that will that GO would contrary to the Rule 93A. That's the position.
Lord, I am
That
not-
argument cannot be accepted.
I am not saying there is age relaxation because of the, my lord, government notification. What I am saying is, my lord, all aided institutions are brought within the purview of the university. And my lord, in the employment notification, page number 102, Lord, the word used is controlled. Page number 102, age relaxation is specifically mentioned there. And it says, my lord, or owned or controlled by the government.
Universities cannot be
The word
controlled by the
control, my lord,
government.
when I say the word control, the question can be what is there on record to show that you control these aided institutions, which is why, my lord, I brought to my lordship's notice that government notification. I am not saying, my lord, that relaxation is provided under that notification. I am saying, my lord, they are brought under the control of the university. And page 102, my lord, the word control is there. So far as age relaxation is concerned. And therefore, my lord, that is the, my lord, principle that is applied.
Okay, thank you.
Very well, grateful.
University is an independent body. It cannot be controlled.
I take
We have heard.
less
Just give
than,
those judgments tomorrow.
I
Please.
take only less than 1 minute for giving a small. report.
We have heard you, Mr. Joyce. Yes.
One is that I have never asked for a relaxation being given by a court of law. The interpretation that courts cannot relax, mother, I have already considered this legal position. I'm not ready to argue against it. Therefore, I requested my little friend not to cite any reason because I'm conceding that position. Then, my lord, he sought to castigate Mr. Pagoji, saying that he was under clouds.
Sorry, come again.
And that is in the appellant number, appellant in 1590. Very unfortunate. That is totally an attempt at prejudicing the mind of the honorable court. I just showed to your lordship, the matter had been closed years before he applied.
The charge sheet.
Charge sheet, my lord, yes. Charge sheet by my lord has been.
The
closed by
learned
competent
judge
court.
did not
Documents
go.
have been
Why
produced.
should we go into
Commissioner has
that?
That is
written that
not,
the
my
matter
lord,
has been
considered
closed
by the-
years ago.
All right.
Therefore, there
Thank
was
you.
nothing, my lord, found in the conduct of it.
Okay, thank you.
I'm grateful to you.
Next.
Sorry if you have taken a lot of time that.
Next.
Because, my lord, they said, they orally said, I was pursuing, they orally said that, my lord, your application has been rejected on the ground that you are suffering from diabetes too.
Forget that.
Huh?
2018 filed, after 10 years, you are invoking and the
Not after
tribunal
7
rightly
years.
relied upon the state of Himachal Pradesh.
Yes, my lord.
Actually, the Supreme Court says so. That's an imminent requirement. The breadwinner has expired, there is no one to sustain, I want an employment. That's the intent. Now,
But-
after 10 years, and that's the reasoning given by the tribunal, I don't think we should take it.
But this reasoning that of the medical officers, my lord, is,
Anything in writing?
oh, they,
Suffering from diabetics or anything in writing?
they say so, sir. They say so that. Kindly, in fact, my lord. Any certificate. I have. Ink page, the translated page, my lord, is annexure. Annexure K, my lords.
Page?
Page, no, I'm sorry, my lord, I have not paginated it. That's what, in fact, I should have done that. That's the objection raised by the office, saying that you have not pagination.
No,
Pagination has not been, the last portion. This is how they say.
What is the occasion? Why this given? What is this?
No, because, my lord, when I sought employment, in fact, I was called for medical test. Then on examination, I was found that, my lord, I was suffering from diabetic. That is, I'm suffering from type 2 diabetes.
Even you have an issue with your eyes.
No, my lord, eyes, no issues.
E 6/60, 6/60,
No, that they don't.
6/9. That's huge.
This is what has been communicated to me.
I don't think.
Principally, they say it is a diabetic.
Very well.
I may be, in fact, my lord, given
When did you get this?
But I got it in 2018, under the RTA, under the RTA. May I be permitted to pursue the authorities, not for re-examination?
Let's put quietus. Let's not, we don't have that expectation. Let's be very clear. What is your age now?
Now 34 minutes, 35. Up to 40, I think he has.
And just keep it in those.
I may be permitted to pursue the authorities.
We will not say. You don't want to, otherwise you will be there, we'll succeed. Not say. And going by the reasoning given by the tribunal, I think they are right.
Tribunal basically goes on the point of delay.
That's right.
Yes, my lords.
2011, you were medically examined. Why didn't you approach the tribunal earlier? Knowing well, you have been examined. What is the result? What is the outcome? Let me know. We'll dismiss it. We'll pass orders. Dismiss. Which is the other matters?
Much obliged.
My lords, in serial number 7.
This is which one? This is better.
My lords, I seek for a short accommodation, my lords.
See, that petition has been dismissed.
Withdrawn. Withdrawn.
Pardon?
Withdrawn, my lords.
Withdrawn.
17 itself.
But that's an IA, we don't know. It's an IA. Just re-notify.
Please.
Any else, ma'am? No, remove that. Okay, don't keep it. That's all.
For appellant.
Friendly, a week's time in friendly, not part.
complaints of the office objections on ES.
Objections be complied with, how much time?
Currently 1 week.
2 weeks. Next,
Delay in respect to delay, my lord.
we'll look into it, remove the objections, na?
Another EA, my lord, EA 1 of 2023, my lord. That is delay in filing the appeal, my lord. Morning, your lord.
You first remove the objections, we will see it. Okay,
Grateful.
that's all.
Date may fix, my lord. Obliged.
My lord,
Just go and come back.
may I, my lord? I apologize, my lord, I am mentioning a matter this, sir, my lord. My lord, there is one matter which we had mentioned, my lord, for an extreme emergency before the honorable single judge. My lord, it was accepted for 2:30, but later, my lord, the registry has felt that it has to be placed before your lordship's division bench. But that's the reason I was wondering, my lord, if I could mention it for tomorrow's listing or in the morning, my lord, however your lordships may permit.
You mention it tomorrow morning, we have
So-
to see it, we don't know. It's a fresh matter.
It's a fresh matter.
Mention it tomorrow morning, let's see.
So grateful, my lord, so grateful.
Madam, 32 Union copy.
Madam, you ಏನಾಯ್ತು?
Video off ಮಾಡಿ.
ಎಲ್ಲ ಎತ್ಬಿಡ್ತೀರಾ ಮೇಡಮ್?
ಮೇಡಮ್ ಮೇಡಮ್ ಕೋಟ 2 ಇಂದ ಧಾರವಾಡ ಬೆಂಚ್ ಕೋರ್ಟ್ ಆಫೀಸರ್. ಮೇಡಮ್ ಸಾಹೇಬರು ಎದ್ದಿದ್ದಾರೆ ಸರ್, ಬರ್ತಾರೆ ಸರ್.
Madam, 32 Union date ಕೊಟ್ರಿ. ಒಂಬತ್ತ? Yeah, short date ಅಂತ.
ಇದಕ್ಕೆ 2 weeks ಅದೇನು 12 ಡೇಟ್ ಹೇಳ್ಬೇಕು 2 weeks. Objections we complain 2 weeks ಅಂತ. ಇಲ್ಲ ಕೊಡಲಿಲ್ಲ ನಾವು ಅದನ್ನೇ 12 ಕೊಡ್ತೀವಿ.
ನಂಬರ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
Yes. Yes. good
Yes, sir.
afternoon.
Yes, brother.
Yeah, just call the person.
Serial number 1, speaking.
For the complaint in this case.
Please, which one? See, we will have it on 28th. Okay, just say this. The judgment
Lordship.
should not be finalized.
28, I've got another suo motu, Your Lordship.
When do you want?
Before
To
that,
come on that day?
yes.
No, so you have a difference. When do you want?
Uh,
29th,
Yes, Your Lordship.
29th.
Because 28, I've got in court hall number 4.
Okay. The judgment could not be finalized, re-notify on 29th.
Please.
Thank you. 29th, we will have it only at 4:25, we'll have it?
Please, minutes.
Huh?
Yes, sir. Or 2:30 may be better.
2:30, 2:30.
This Thursday.
Okay.
Serial number 2. Serial number 2. Kiran Babu Pati in person.
Yes, Mr. Babu.
The only
Please
question
show
for
us the-
consideration is whether this honorable court may be pleased to grant certificate.
Pardon, grant certificate. See, this not, issue is not such which requires certificate.
Yes.
But you are within your rights to go to Supreme Court.
That is, I have to invoke 136 otherwise.
That's right.
Yeah, but I prefer invoking 132
Yes.
or 133. So,
The Constitution. See, all is based on a judgments.
yeah, 132, 133, I have a greater advantage. But if I go for 136, then it is the discretion of the Supreme Court.
The
130.
question is not res integra. Question is not res integra.
Hmm.
And as such, no,
And my humble submission, I have filed a memo, my lord, and then, however, it is a discretion of the court. There are substantial questions in law and the substantial question in
No,
context,
Mr. Babu, not in these facts. We have considered it, the law, everything.
but there are there is a memo, I suppose. So
So we have that memo before us. We have filed it on 26/7. It's there before us.
There are some questions, my lord. I presume this honorable court didn't have, probably didn't have looked into that for consideration.
This,
So, but the primary question is whether respondent 2 is within the meaning of person or not under the section 3 and subsection 42 of General Clauses Act. That is not definitively has been decided. So if that has been decided, the question is whether the High Court under Article 226 has the power to issue directions, orders or writs. I did not anyway,
it's all right, Mr. Babu.
my
We
lord-
have heard you a lot. We
Yes.
have dealt with
But
everything.
that point has not been,
It's all right, please. This
My-
is
my
a, this
humble
is a
submission-
memo, this is a memo.
my lord, just 1 minute.
Yeah.
And the question 2 is whether that this is very crucial question, whether the judiciary has the power to interpret the provisions of the Constitution.
We have dealt with.
No.
We have dealt with everything. Maybe
Yes, please give me 1 second.
this is a memo filed by the appellant under Article 134A of the Constitution of India.
My lord, the lordship may kindly forgive me. 1 second, madam. I have filed a memo for whether the court may grant me liberty to remove the state, my lord. First respondent. First respondent, the state.
It's all right.
So,
Full stop. This is what memo, ma'am? We have only one memo?
no, there was another memo.
It's all right, Mr. Raju. Full stop. We are not given the, have given the facts which arose for our consideration. Given the facts and the issue which arose for consideration, we do not see it's a fit case for grant of leave to appeal. Grant of
certificate.
a grant of certificate under Article 134A of the Constitution of India. So stop. The memo is rejected. Thank you. Thank you. Thank you, brother.
Yes, sir.
This one, this one,